Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share.
What they did to her was ungodly and unfair. Nobody deserves it.
Hello everyone and welcome back to another live stream with me, Grizzly. This is Grizzly True Crime, and today we are here for day 7 of the Sean Finnegan trial. It's the beginning of phase 2, which is the sentencing phase, or sometimes known as the punishment phase. And the judge, just from the little bit I heard this morning, was like, we want to power through. It's going to be like opening statements again from both sides, the state and the defense. There's going to be aggravating factors from the state, and they might have a witness or two. There's going to be mitigating factors, and this is all about the death penalty, of course, right? From the defense, and I think they said they'll have a witness, and there should be closing arguments, victim impact statements, all of that. And then the judge is thinking the jury might start deliberating on whether Sean Finnegan should be sentenced to death or not today. Like, oh my word. So we have a full day ahead of us. We started, of course, intentionally later if you're watching live with us, so that we could just skip over all the breaks. And there were many breaks so far from what I could gather. So it's going to be lunch break, coffee breaks, breaks after speaking to the attorneys and all of that. Okay, so are we ready, everyone? Here we go with day 7. The judge has just arrived in the courtroom here, and I'm sure later we'll catch up with the feed. But for now, here we go.
Before we get to our motions today, one of the alternates is having a difficult time, which I certainly understand. But I really don't know how to handle it. I'm thinking about asking the 12 when they get in here how they're all feeling. If they're feeling okay, then I'm thinking about just letting the 2 alternates go. But I know there's a risk. Or I can talk to the 2 alternates about their issue. One of them saying that the way we...
Listen, mofo, are you wearing purple? I don't think so. Purple is, it was Jennifer Paxton's favorite color. I went to put on my purple heart from the previous stream we just had. I know it looks bluish. It looks bluish on camera, but it is a purple heart, okay? What? Stop it. Okay, so the jury's not yet in the courtroom. This is all just the judge speaking to the attorneys, okay? The jury's not yet there. Obviously, Sean Finnegan's there. And if you didn't see the verdict yesterday, whenever it was on day 6, it's on the playlist. Go and check that out as well. There were 13 counts. He was found guilty on 11 of those. All right.
We picked the alternates was rigged, which is kind of funny, but that's kind of what I'm saying. Then I go back in the back and picked them. The first 2 on me, even though you saw me pull them out up here. But that's just today's environment. So I don't really want him on the jury if somebody gets off, but I'll do what y'all think. Basically what I was thinking was lecturing for a minute about how inappropriate that is, and then second saying, but if any of y'all don't feel like you can do this, and here's the risk, if I lose somebody, we gotta do it again. And all these people spend hours and hours working on this, but if y'all don't feel comfortable, because we may not get done today, they may have to spend another night. And I think he told one of the police officers he wouldn't stay another night. He was going to go home. So,
what the hell? One of the alternates is saying that they believe that picking the alternates was rigged. But we all saw it on camera how they were picked. The only thing I saw, it wasn't out of a mug, okay? It was out of a basket. I'm like, why did the judge not pick it out of a mug, like you said? But it rigged. One of the alternates is so upset that they are an alternate that they say it's rigged and they will not be spending another night in that hotel. Like, oh my word. Okay then.
You got any feelings about it all?
I have a lot of feelings, Judge.
Yeah.
It's not something, of course, that we deal with
Right.
regularly, and we want to do everything on the evidence, but we can't just
assume that everything will be okay on it. I think.
I mean, it's a very difficult job being an alternate. It's probably the hardest job of anybody here, and I recognize that. But still,
I'm definitely not unsympathetic to the situation they're in. That would be difficult. But I think perhaps maybe the lecture is appropriate because I don't think we can take a risk and just let all the alternates go because we never know what happened. But again, we want people to understand the gravity of this, and despite the discomfort, this is a very important situation for everyone involved.
And then the alternates will get to sit in here all day today and hear all the stuff today. They just won't be able to participate in deliberations. But does the defense have any wisdom they'd like to share?
I'm just kind of curious now, so I mean, I know who it is. I've already offended him once, so I'm assuming.
Oh my word, this is unbelievable. Kit Rogers there, the defense attorney, says, well, I think I know who it is because I think I've already offended him once. So this juror, yeah, pack your baggies. Pack your baggies. Okay, guy, you think it's rigged? He's so salty of what? Why? Because you're an alternate. I know it must be hard to be an alternate, to be there for all of this and hear all these terrible things and then not be able to deliberate. But it's it's how the process works. Kathleen said, just as well send them on their way. We don't want people like that thinking like that on the jury. Bye. And now even Kit Rogers, the defense attorney, says, yeah, well, I've already offended him once. So the judge is like, The judge is like, I was thinking of lecturing him a little bit, but what do we do, guys? Oh, my word.
Great legal argument. Yeah, right. Yeah, why not?
I guess I might not know this, but obviously we have opening statements. Y'all put on proof. First of aggravators, mitigators if you got any. You don't have to, but if you do. And then if y'all want to put on rebuttal, you could. And then we do closing arguments. So I guess my question is, do you anticipate that we could get through this today enough to where I can get it to the jury? Or you think we just spend the night?
The state's aggravators, we believe, are proven in our case in chief, and we will be putting on victim impact testimony. I believe with my conversations with the defense yesterday that they expect about a half day of proof for them. So I think it's plausible that we finish this today. Close. It should be a matter of deliberation.
One short witness and then one family member that'll.
Okay. And then
she just kind of speaks deliberately, so
sure.
it'll just take a little while to get through the family history. That's all.
So I guess though,
maybe even by lunch or right after, if you break in the middle of her testimony. I was thinking about this because I think the court has been sympathetic to the jurors' lunch schedule, whatever, and so you've been breaking in the middle of testimony, and I just foresaw being in the middle of hers and somehow lunch getting here. That's my only thing that would drag into the afternoon is what I'm trying to say.
Okay. So you'd rather if we didn't break for lunch, would you rather finish that witness? I'm going to do what you asked me to do.
I think it's just a matter of timing. You know, depending on how. I'm not trying to slam through her testimony. It's just depending on where we are in that, narrative.
And what would be your feeling if I told them I want them, or we were going to bring their dinner in tonight? Instead of going back to the hotel. Y'all have an objection if I get to that point and say, okay, if I get to the jury tonight, we're bringing dinner in tonight.
I don't have an issue with that. I don't want to speculate on where the jurors' minds are, but I imagine they might want that too.
Right.
It's been a long week-ish.
Okay. We'll see how it goes.
Yes, sir.
All right. So let's talk about, I think that the defendant has filed on 48 proposed jury instructions. I think I need to hear you argue each one of those, and as we go through each one, we'll stop and then let the state respond, and then we'll go through it that way. Is that satisfactory? And I think the first one is your proposed charge into the defendant's right not to testify.
Yes, Your Honor. Come to the podium.
Would you be more comfortable sitting there?
I would.
Okay, sit there then.
Okay.
And y'all can sit there too. Okay. Go ahead, sir.
Judge, I think I have a similar. I'll just start by saying I think I have a similar bases for all of these in the sense that I have, to be honest, taken these from a source that is a useful handbook in my line of work, and I have quoted what I think is appropriate constitutional and case law for most of these. Most of them are founded on federal and state constitutional principles. Some generally, some with case law citations, but I'm just going to speak generally as we go through these. And I would say that, not to get ahead of myself, but in the event I'm overruled, it would just be an Eighth Amendment objection across the board and 14th Amendment. So, saying all that, we think it's appropriate that the jury be reminded that Mr. Finnegan does not have to testify at this phase, and he's not making allocution either.
And if he chooses to, we have to have another moment. If he chooses not to testify or what, otherwise we still have to have another moment.
I agree.
Okay.
I agree.
All right. Do you want me to go ahead and rule?
Oh, I'm sorry, Judge. Yes.
Do y'all have anything you want to add?
We don't have an objection to an instruction that he has a right not to testify, but we feel like the TPI is sufficient.
Right. And so what I'm going to do is I'm going to charge 43.03B, which I think covers the same, not the exact same language, but certainly covers the same issue. So I'm going to charge that. We're noting your objection. And so then let's go to number 2, aggravating circumstances.
And Judge, forgive me, but I did put a lot of these in just globally.
Sure. And
some of them are redundant, I will admit, and overlap.
No problem.
Just out of an abundance of caution.
We're good.
All right, thanks. So this is just an instruction on what the aggravating circumstances are and the presumption resulting from them, Judge.
All right. And I'll work on a draft charge for that. I may not use that exact same language, but I'll certainly cover.
Sorry to pause it right there. So the jury's not yet in the courtroom. The judge started this around 8:30 a.m., their local time, with the attorneys, and he told the jury to be there at around 10 o'clock. So they only talked for about half an hour, just planning, all the... Obviously, I lurked a little bit just to see how long was this and how long was the break, because I want to time it so we can skip over breaks, okay? So I wanted to see how long is this. So about half an hour or so, they're going to just go over, some of the plans for the day, for what are they going to present, aggravating, mitigating factors, the charges, all that kind of stuff. So we were just going to watch that a little bit, and then we'll skip over the long break, and then we'll get to everything else. Angela, thank you so much. Thank you all for being here. Please like and share so that others also know we are live right now and covering this trial. Of course, this trial says all the YouTube naughty words that all those AI bots for YouTube are listening to and saying, you know what, we're not going to show the stream to anyone. There's a lot being discussed here. That's not right for a PG-13 platform. So yes, it is true crime. And so if you guys like and share, at least other people, it gets it more in the algorithm. Other people will know we are live and they can come and join us here, especially if they didn't get the notification. All right, here we go. Let's continue listening.
That issue. I think that's an important issue. And then next is sentencing options.
Yes, Your Honor. I think that this jury is called at this stage to make one decision only, and I think I believe the court will, but I think they have the right to be instructed on what exactly the sentence. We've talked about it ad nauseum, but these are the options.
All right, and I'll cover those options in my draft charge and show it to you as well. I too want to work on making it a little bit clearer so that they understand exactly what those options are.
Yes.
Next is the jury's ultimate responsibility.
Yes, Your Honor. This was in an attempt to prevent the state from somehow distancing them from their ultimate responsibility. In this case, in the event the state were to do that, I'm not saying they are, but we wanted it to be clear that the jury knows they are the ones making this decision.
What's the state's position on this?
The state believes this is an unnecessary instruction. I think it will be clear, and especially through the TPI, it is their decision. That's why they're here.
All right, I kind of agree. I'm going to decline that request. Next is decision to be made by individual jurors.
Yes, Your Honor. Again, they work collectively, but I think it's important to remind them that each of them is a jury unto themselves, and that they each have the right to make their own independent evaluation in sentencing.
Yeah, I agree with that, and I'm probably not going to use your exact instructions. I'm going to work on it, try to make it a little bit clearer. I'm not sure TPI is as clear on that as I'd like to make that, but I'm going to work on that for you. Then next is the...
So I'll put a maybe next to number 5.
Yeah,
to be determined.
Maybe.
Yes, sir.
I can tell you I'm not going to use your exact language. I'm headed down that path. 6 is aggravating factors considering only statutory aggravation?
Yes, Your Honor. The state has, in their notice of intent to seek sentence of death, has provided statutory aggravators. I've not seen any notice of non-statutory, so this may end up being moot.
Yeah, I agree. Then next is aggravating circumstances definition.
Again, this may be redundant, Your Honor, but I think the court has its own instruction, but I just wanted to include it.
Right, and I think I'll use my own instruction in regard to that.
Yes, sir.
Next is weighing aggravation and mitigation.
Yes, Your Honor. This kind of breaks down the different weights relative to each side's burden, I suppose. Of course, we don't have a burden, but I think it's important for the jury to understand the kind of, it's almost like an extra burden in this sentencing phase and so I think this instruction encompasses that legal principle.
What's the state's position on that?
Again, we believe that the TPI is sufficient for the instructions, and they've been instructed ad nauseum from the time we were picking the jury that they have to consider mitigating and aggravating and balance those.
Yeah, I agree. I'm going to deny that request. Number 9, defining aggravating and mitigating factors.
It's just a definitional section, and I'm sure there is an equivalent in the TPI, but I wanted to include our version.
And I'll do the TPI one.
Yes, sir.
Then next is aggravating circumstances reasonable doubt definition.
Again, Your Honor, just an attempt to provide our own version of
Sure.
What we feel is the law.
And I'll probably do the TPI one on that or the reasonable doubt. Then next is burden of proof in aggravating circumstances.
Again, and apologies for redundancies, but nevertheless, we've got them all in here. And so I think, again, it relates to the sort of higher bar the state has in this phase.
And I'll consider that. Like I said, I'll probably fall back on the TPI instruction in regard to that. Then next is aggravated circumstances standards for consideration.
This is just to remind them that the aggravating circumstances alleged are just what they are. It's an allegation. I wouldn't even call it a criminal charge because it's not gone through a grand jury. So it's just to reinforce that these are just allegations.
I'm going to deny that. I think that's already going to be in the charge. Next is presumption regarding aggravating circumstances.
Again, this relates to number 12. A little different, but it's to remind the jury that these are not proven unless and until they find that they've been proven.
And what's the state's position on that?
Again, we believe that TPI is sufficient and the instructions as they exist are sufficient.
I agree. I'm going to decline number 13. 14, aggravating circumstances, unanimity.
I think it speaks for itself, Judge. We just request the inclusion of some instruction as to unanimity.
Yeah, it's a correct charge, but I'll add a similar charge to my jury instructions. Aggravating individual consideration but requirement of unanimity.
I know it's that word.
Right, I almost got it. Go ahead.
Anyway, this again reinforces we believe that they have to be unanimous to find aggravating circumstances, but that they should exercise their own independent judgment.
And I think that's already in the TPI charge, but I'll make sure that area is covered. Then next is first degree murder is not an aggravating circumstance.
I think that's been rendered moot by the verdict.
I agree. Then next, 17, felony murder not automatically an aggravating circumstance.
So I think if I had any of the, well, I'll get to what the ones I really think are most important, but I think this one is very important in this matter to explain to them that just because he's been convicted twice of felony murder, that itself is not proof of an aggravating circumstance.
And what's the state's position on that?
Your Honor, please, it is an articulated aggravating circumstance that we filed notice for. I believe that we were able to argue that. I don't think there's anything that is automatic, so we certainly have to prove that they found him guilty of these, and now we have to tell them that they weigh whether that is an aggravating circumstance. I think this is muddying the waters.
Right.
Really,
I agree. I'm going to decline that request. Number 18, crime in society.
This is just to, these are more defensive instructions to prevent or preclude the state from arguing about this theory at sentencing.
Sure. Don't argue crime in society, but I'm going to deny that request unless y'all argue it and then they can bring it up. Next is deterrence cost.
In a similar vein, Judge, it's to preclude the state from arguing that factor.
I'm going to decline that unless they bring that up in their argument. Then next, mitigation reason for sentence less than death.
And this is really just kind of a heading instruction where we just, we add in our list of statutory and non-statutory mitigators that we file.
Okay. I'm going to decline that one. Then next, mitigation definition, weight, and unanimity.
Yes, Your Honor, this is just our proposal.
It's kind of a combination, kind of bring it all together.
Yes.
Right? Okay. I think I've already got that in the charge, so I'm going to decline it in this form as you suggest, but you need to review what I say about it in the charge that we do.
So welcome to anyone just joining now. This is the sentencing phase. So it's not just like sentencing day, because it's a death penalty trial. So there's two phases to a trial when it's a death penalty trial. And so they already did the guilt phase. He was found guilty on 11 out of 13 counts. Okay, we went over that in the verdict stream, so go check that out. Okay, you can hear them all over there. And then now we're at the sentencing phase. So it's kind of like another mini trial because there's again opening statements, and then the state has to present their aggravating factors for why they believe that Sean Finnegan should be sentenced to death. And then the defense will present their mitigating factors, which some of you are saying, lol. Some of you are like, what mitigating factors? But as I put a comment on the screen earlier, like Rebecca's involvement could be one. I'm sure the defense will go there again. The lack of Sean Finnegan's DNA, okay, through the testing. There's a few others there that they might look at that as well. But they'll present that, and then there might be closing arguments again. I think there would be. And then the jury will deliberate on whether Sean Finnegan should be sentenced to death or not. And I believe if there's 12 jurors deliberating this, it has to be 10 of them that agree that he needs to be sentenced to death for that to be a unanimous verdict. I think that's how that works. It differs per state, so I might be wrong. As you know, I'm not a lawyer. But from what I've learned so far, I think that's how it goes. Let me know if you're a lawyer, especially in Tennessee, and you know. But that's what we're doing today. The sentencing phase, the jury will deliberate. They'll come back with yet another verdict. We'll have another verdict watch and another verdict. And then eventually there'll be sentencing. Sometimes it's immediate sentencing. Sometimes they schedule the sentencing. I don't know what's going to happen in this case. We shall see.
Let's see. Mitigation, standard of proof. I think that's a correct statement, so I'm going to do that one.
Thank you.
Number 23. Mitigation cannot be considered as aggravation.
I think that's important. Again, I don't think there's going to be extensive proof in sentencing, but I think it's important to remind the jury that even if there's other bad things that are brought out in my client's mitigation phase or the presentation, that should not be considered as an aggravator.
Okay. I'm going to deny that request. Next, general closing instruction. Sentencing phase, and basically you've got kind of the same language as in TPI, it just kind of expands it.
It does.
I'm probably going to deny that as well. You can review the one that I'm going to submit to you.
That's right.
And then let's see. Then 25, doubt endures to the benefit of the defendant. Tell me about that, because I already charged reasonable doubt. Tell me why I need to do this one.
I'm satisfied with the reasonable doubt and explanation, Judge. I will
consider. And then I'm interested in 26 in mercy.
I think the jury, I think in mitigation, the jury is permitted to, as long as it's based on the evidence, to consider, to make their own individual decision. And I think that's just to remind them that this phase is different than guilt and innocence, and that they can rely on their own morality and sense of mercy in reaching their decision.
What do y'all say about applying mercy?
TPI is sufficient, and we believe that they can make, they have a wide breadth on what arguments they can make and mitigation factors.
So they can argue for mercy.
I think they're probably permitted to do that, but I don't believe it needs to be an instruction.
Okay. I'll review the instruction, see if I'm satisfied with how I cover it. And then next, consideration for sentence less than death.
I think this is a continuation of 26. It just expands it, and so
that's exactly right. That's exactly what I wrote down. So I I think I covered in 26, 28, 29, 30, 32.
And
So,
again, Judge, as I said in my intro, I think some of these may overlap,
yeah.
turn into a Venn diagram.
And I think that same thing applies on 28 as well.
Yes, sir. And 29.
And 29 is, you're asking about sympathy. So that's kind of the non-statutory mitigator, kind of the catch-all covers that.
Yes, sir. Yes, sir.
Okay. I mean, I use those exact words, but I'll cover that in my instructions as well. Then the next one, I think we've already done that, mitigation.
Sorry, didn't mean to interrupt you, Judge. I think this again is related to the general mitigation definition.
All right. Then 31, I think it's already in the charge. I just kind of use different language.
Okay.
Let's see. 32, so I guess my question is, are y'all asking for mercy as a non-statutory mitigator? Or are you just going to argue it?
I think I'm just going to argue.
Okay. So I will not list it as a non-statutory mitigator. Then next, finding beyond a reasonable doubt that death is appropriate. I think that's already in the charge, but I'll review it to make sure it is. And you can look and see my work as well, see if it's okay.
Okay.
And then this fairness or proportionality, are you just going to argue that, or is that going to be a non-statutory mitigator?
I think based on the verdict, it absolutely should be a non-statutory mitigator. And I would be arguing it as well. I think this is a cornerstone of my argument today based on that verdict.
Okay, I'll take a look at that, consider that. And next is residual and lingering doubt. I think you listed that as a mitigator.
Yes, Your Honor, and I think I would like this included. I think perhaps it has less relevance based on the premeditated verdict and the not guilty on the conspiracy to commit first-degree murder, but I still think it is appropriate because we're dealing with two people, two actors in the same event. So I think
if I did that and you listed it as a mitigator and can argue it as a mitigator, am I not giving it a kind of a boost or a supercharge if then in addition to you arguing it as a mitigator and I charge it as a mitigator, then I give an instruction on it?
I just respectfully ask for whatever.
Okay, I'll consider that. And then inability to agree.
I think it's probably covered somewhere in the TPI, but I just wanted to make sure it was considered that they were given instruction on what to do.
Right. So that was I think that was 48, if I remember correctly.
Yes.
Good. And then tell me on 49 what you want me to do.
Yes, sir. Give me just a second.
This defense attorney's name is Forrest Wallace. The other one is Kit Rogers. We haven't seen all that much of him, but we've seen quite a lot of this defense attorney today.
Lost it. Judge, our motion limine 49 deals with the state's notice. Here it is. It deals with the state's notice of intent to seek death. The state has alleged in their notice for 6 statutory aggravating circumstances. And specifically, this motion addresses the felony murder aggravating circumstances, which the state has listed as 7A and 7B. And based on my review of the statute and the case law that's related to this, we believe it's inappropriate for them to be able to consider that twice. And we think now they can say it relates to 2 different charges. That's fine. We think it's only appropriate for the jury to consider one single aggravating circumstance as it relates to a string of felonies committed in perpetration.
All right, so you're saying that instead of arguing both felony murder on kidnapping and felony murder on rape, that they should just consider felony murder. Is that right?
I think so. were at least included. And I just don't want, I think it's kind of, I think it inflates inappropriately.
Right.
Yes, sir.
Okay. What's the state's position on that?
State's position is, of course, I believe the state of the law is that it can only be considered once, but this, we would combine that, say this is one aggravating circumstance that applies to kidnapping and rape in the felony murder context.
Okay. I'll work on that. Let's see. And then the last thing I think was number 50, and that's just where y'all filed your notice of mitigating circumstances.
it is, and unfortunately I filed that first, and I realized I'd skipped two numbers, and so it turns out I had 2 other motions to file, so I think everything is correct sequentially. But yes, that's our notice.
All right. And then,
Judge,
yes.
just for the record, did the state have any response to that?
Okay. Does that respond to their mitigators?
No, Your Honor.
And then I've got the victim impact letters. Have y'all seen these? Have y'all reviewed them?
We have.
Okay. Are there areas? Go ahead.
We do have a family member who has added a paragraph that we have just received, and of course we'd like to proffer that in front of the court.
Sure. And I'll look at.
We'll make it. You want to make a copy for you, Judge?
That'd be great.
Additionally, they're telling me that Jennifer's grandmother, who raised her, she's elderly, but she does want to make a statement, and that's on its way. So
is the grandmother going to be here? Or it's like
Yes, no, she's going to be here today.
Okay. All right. So I'll have to.
As soon as we get that, we'll forward it to the court if the court's
But
consideration.
the one that's got the added paragraph.
Can I hand you the original, Judge, up there so you can read the added paragraph and decide?
Why don't we just get a copy of it made?
Okay.
And then I'll look through it, and then before I bring the jury back, we'll go through and read that additional paragraph on the record. And then hopefully by then the grandmother will be here and she can read hers.
Yes. What time will she be here?
They were on their way. There was an accident.
Okay, good.
Thank you.
I'll do that. And then if y'all reviewed it, if there's lines in here that y'all have objections to, if you could just give me a copy that highlighted what you had objections to, then that way I can look at it. There were a couple of lines I need to take out from the last lady that read hers that I haven't done yet, but I'm going to take those out.
And I think that's appropriate. We don't have any other objections, Judge.
Okay.
We think the court has moderated that sufficiently.
All right.
Notwithstanding whatever.
Right, what the other one says. Sure. Okay, anything else from the state you take care of? Anything else from the defense? So probably if the jury gets back here at 10, I may go ahead and take care of well, no, you said not to do that. You said take care of the 12 jurors first.
Make sure they're all done.
Right, and then take care of the alternates. Okay, so I'll bring the 12 jurors in first, just check on their general health and well-being, and then I'll let them go back. Then I'm going to bring the 2 alternates here and have a little visit with them and then make some decisions based upon their deal. Is that okay?
I just love the judge. Bring in the jurors, check on their general health and well-being. Okay, then we'll bring those 2 alternates in here. Have a little visit with them because of the one being naughty. If you missed that, there's one alternate that's all salty now because they're an alternate and saying this picking of the alternates was rigged and they're not staying one more night. But I mean, this whole trial could be over by today, Tennessee time, tomorrow at the latest, it seems like. I mean, the jury's probably going to start deliberating today on the death penalty. That could take them some time. But I'm like, maybe it's one more night in the hotel. And that one is just like, I'm not staying another night. Naughty, naughty juror. So that's what they are talking about. Beauty from within, out nails, makeup. Thank you so much. Thank you so much for your sticker.
Yes, Your Honor.
Okay, all right. Thank y'all very much. And so we'll start back at Thank you.
Shall we stare at the wall for half an hour? Or shall we teleport? We know the answers, Grizzlies. Buckle up. It's time to teleport. Here we go. Okay, we go forward to where they came back with the jury, of course. The jury was asked to be there at 10. Damn, that was a long break. Here we go. Still going. Oh my goodness.
Your Honor, please, her granddaughter will be reading on.
Okay. They'll be back in a moment. Thank you so much all for being here. Please like and share. I hope you'll catch up on the other days if you didn't see it. If you're brand new to this trial, do check out the trial prep and then day 1. Oh my word. Sure, Rebecca's testimony, his former girlfriend.
I can do the victim impact Statement for her, please.
Your Honor, please, her granddaughter will be reading on her
Okay.
behalf.
Granddaughter can come up.
Okay, they're going to be reading the victim impact statements now. All right, all right.
No, we're fine. Stay up here, please, ma'am. You raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you. There's that. If you'll tell me your first name and last name, spell them both, please.
Okay, just hold on. We're going to listen now. Awesome. Natasha says, I would be mad if I was an alternative. Well, it sucks for them. It does suck for them, but it is part of the process. And I don't think that they should be, you know, like throwing tantrums about it or threatening to leave or blaming the judge saying he thinks it's rigged or they think it's rigged. I don't think that's fair. It just is what it is, you know? So, okay.
Brittany Payne.
And I believe, go ahead and spell it. I'm sorry.
Brittany Payne.
And if you'll go ahead, and I think this is your grandmother's statement.
Yes.
And she wrote it out for you.
Yes.
Okay, go ahead.
Jennifer was my granddaughter. I loved her dearly. Losing her destroyed my heart. She was my everything. When Jennifer went missing, we searched everywhere for her. Not for days or weeks. We searched for 8 months. When Jennifer was found, sadly, it wasn't the news we was hoping for. When I learned of Jennifer's death, a part of me died as well. I struggle every day. The anger, the hurt, and the despair is indescribable. The nightmares that I still live with to this day will not go away in this life. The only thing that helps me get by from day to day is knowing I will be with her again one day in heaven. Thank you, Mildred Cordy.
Thank you very much, ma'am. I'll take that back. And
Shame.
later on,
This is Brittany Payne, Jennifer's cousin. She's been in our chat here. You might recognize her handle as @Nicole. I think she may have changed it now to @Brittany, but she's been here with us, and she shared with us that Jennifer's favorite color was purple. That's how we know. So thank you so much to Brittany for being here and feeling safe in our chat. That's always the goal here.
when we do victim impact statements, you'll be reading this for me, okay?
Okay.
All right, thank you. And I know the state's aware of State v. Nesbitt, but it does give us some direction in regard to how you should argue these victim impact statements. It says, arguments permissible, but restraint should be exercised. Do not argue what is little more than an appeal to the emotions of the jurors, as such argument may be unduly prejudicial. The jury should not be given the impression that the emotion may reign over reason. Number 2, argument on relevant though emotional considerations is permissible, but inflammatory rhetoric that diverts the jury's attention from its proper role or invites an irrational, purely emotional response to the evidence is not permissible and should not be tolerated by the trial court. And 3rd, argument should not characterize the victim impact evidence as an aggravating circumstance to weigh against mitigation proof. So what we're going to do to start off with is I'm going to bring the 12 jurors in for just a moment, check on their general well-being. Then I'm going to excuse them. Then I'm going to bring in the 2 alternates and discuss their situation. I'd rather if my friends on Court TV did not tape me talking to the 2 alternates, which I don't think you do anyway. And then I'll decide what I'm going to do with them based upon their responses. And then after that, I'm going to go back and check with Ms. Jones for a minute and come back and give y'all a copy of the jury charge that I anticipate giving, so at least you'll have a moment to look at it before we start the proof. Is that satisfactory? Yes. Okay, if you'll bring her.
So everybody repeat now what's going to happen next. Were you listening? Are you awake? Okay, so I'm still just laughing because the judge is like, all right, my friends there at Court TV, please don't be filming that, me talking to those 2 2 alternates. Stefan's like, we're going to discuss the situation. So we won't see that. But we might see now him. They're going to bring in the 12 jurors that are deliberating, that had been deliberating, that chose, they voted guilty on 11 out of the 13 counts, okay? Then send them out again. Bring in the 2 alternates. We're not going to see that, okay? Then they get sent out. The judge will discuss the situation and see what to do with them. And then, I think then after that, the jury will come in and the day will begin, which is the sentencing phase of this trial, all right? Okay, so let's see.
12 jurors in.
All rise.
Yeah, Lee's like, just judge having a little visit for the alternates. Yes. I mean, it obviously must suck to be sequestered this whole time and be an alternate, not be part of it, be in a separate room, not be able to talk to anyone. I get it. It sucks, but it's like, it is what it is. It's part of the process. Right? And how do you know they won't need you at some point? Okay, so they bring the 12 in. Here we go.
Have a seat. Good morning. I hope all of y'all are well. Let me kind of tell you what the plan is for today, and then what my plan is for this morning. First of all, the way this will work is very similar to the trial, except it'll be a lot quicker. We'll have opening statements by the attorneys in regard to the aggravators and mitigators, if the defense decides to put on any mitigation. Then we'll proceed with the state putting on proof of its aggravators. Then the defense can put on any mitigators that it wants to. The state could put on rebuttal, and then they do closing arguments, and then I give you the charge. And it's a lot shorter charge, so I won't be reading for an hour and a half, so that's a good thing for me. And then I'll let y'all deliberate. So the possibilities are good, not great, but good, that we'll get the case to the jury to y'all today, maybe by 3 or 4 o'clock. And then I'm going to kind of leave it up to y'all. I've made arrangements for dinner to be brought in tonight, so if y'all want to keep working, do dinner and eat dinner in there and kind of get through, then we can do that. If you say, I don't want to do that, you want to come back tomorrow, you can do that. Y'all are in charge of this. But there's a possibility, if not, if we don't get through all that today like I hope, then what we'll do is we'll come back tomorrow morning and you begin deliberating. And then we'll finish tomorrow. So that's quicker than what we anticipated, so that's a positive thing as well. And that's because of these lawyers and the way they present their case, and also by the way y'all work. So that's something positive as well. So this morning, after talking to you, I've got just a couple more questions. After talking to y'all, I'm going to excuse y'all for a few minutes. I need to talk to the 2 alternates, because if I keep alternates, they're going to be staying in here too. They'll be sitting right down here. They'll have their juror notebook just like y'all do. And then when we take breaks, y'all will take your break. They'll take their break away from you, and then we just kind of roll like through that. So that's kind of the plan for this morning. So hopefully, I'd like to get y'all in here by about 10:15, 10:20, and start on proof. That's kind of what the plan is. I didn't ask you this. You remember in the past I told you not to talk to each other about the case or the circumstances and all that. I need to make sure that nobody last night had any conversation with one of their fellow jurors or anybody else about the facts of this case or your verdict or anything along those lines. If that's true, raise your right hand. Perfect. Thank you. So that's good. Let's see. Number 2, kind of a personal question. I need to know how y'all's health is, because that's going to affect me on what I do with the alternates. Everybody feeling okay? If you're not, that's okay. I just need to know. But if everybody's feeling okay, if we have to spend one more night at the hotel, we think we can make it through that. Everybody feel that way? If you do, just raise your hand. So, okay, good. I feel good too. So we're all in good stead. Okay, so I'll bring y'all back in just a few minutes. Everybody still take the jury out. Everybody rise, please. All right. If you'll bring my 2 officers in after we get them in the jury. Okay.
Then they're going to bring the alternates in, right? Stefan said the alternate can still write a book about the trial. Pernille, how did you word that? Oh no, where's your comment? It was so funny. Oh my goodness. The judge to the alternates. Y'all get out of here. You hear? Get out of here. Oh my word. That one saying it's rigged. I mean, it's pretty offensive, right? The judge is probably like, what? I mean, he runs a tight ship. Be the lighthouse.
Thank you. Have a seat for a minute until we bring the alternates in.
Okay, now the friends at Court TV have been asked to please not show this part where the alternates come in. So unfortunately, we're not going to see that. It's a bit of scolding or whatever it could be. Just a little bit of a pep talk, maybe. A little discussion. So now we teleport again. As you can see, this is why we start later. We would have been sitting from here. 2:05. Sure. All this time we'd be waiting. So here we go.
that I didn't do exactly what y'all asked me to do.
Wait.
Noting your objections to it, that I didn't do exactly what y'all asked me to do. Everybody rise, please.
Okay, so the jury is now going to come back into the room, and the sentencing phase is probably now going to start, because that's what the judge said would happen. Talk to the alternates, take a little break, and then bring the jury in, and off we go. So it'll be opening statements from the state and then from the defense for the sentencing phase. Buddy Hembry says, it sure takes a lot of time to decide D or life without parole for someone who is guilty of quickly ending the existence of another without mercy. Thank you, Buddy, for your sticker. Okay.
And if we can bring in our other 12 jurors, please.
Oh, okay.
Yes.
Monica says, who did the alternate say that to? I believe to a police officer. The judge said earlier that that the one who has a problem with saying that the alternates picking them was rigged said to a police officer they're not staying. I don't know if they've got like security or what, I don't know. But they said they're not staying one more night. And I don't know if they then told the judge that as well, right? It sounds like they spoke to the judge too.
Thank you. Everybody have a seat. Record and reflect that our 12 jurors are back, and we've got our 2 alternates back, so your friends are back here now. The difference today will be that when we take breaks, you 12 will go take your break, and those 2 will go take their break. And so there won't be all together. And once again, we can't discuss the facts of the case or the mitigation or aggravators that we're going to learn about today until we get everything done, and I give you final jury instructions like I did the day before yesterday. So that's kind of the plan today. All right, so opening statements, please.
Sean Finnegan should be given the same amount of mercy that they gave Jennifer Paxton. In this case, the first entire portion of the case, we talked about the crime, and now we're talking about the consequences. And the crime, you've held him responsible for first-degree felony murder and 2 different counts. And that gets us to the point where we talked about in voir dire, once you establish that he's committed first-degree murder and he's responsible for her death, then we get out those scales that we talked about. And the scales that weigh the mitigators versus the aggravators are important for a couple of different reasons. The first of which is to distinguish this crime from other crimes. And that's what the aggravators are for. That's why they've been enacted. They're to ensure you as a jury that you're seeing that these crimes, based on the statutory aggravators of this crime, is distinguished from others. And let me run by you a different set of facts, like, for example, a drive-by shooting. And this isn't to mitigate or to denigrate drive-by shootings. They're terrible for communities and for people and the people involved. But if somebody gets into a squabble about something, be gambling, drugs, whatever, and then returns to the other person's house that they're squabbling with, sees him in the driveway and shoots him in the driveway, that's a first-degree murder, right? I mean, there is those things happen in our community. But if you want to compare and contrast that to what's happened here, and we'll highlight that when we talk about the aggravators here in a second, there are aggravating factors to this homicide that make it special, that make this worthy of no mercy for Sean Finnegan and make it worthy of the death penalty. And when we talk about the scales that you put out, you're going to be looking at the aggravators, and the state only has to meet one aggravator. The legislature has imposed and given us what those aggravators are. And when you're going to be looking at those aggravators individually, and if you find an aggravator beyond the reasonable doubt, you put it on the scale. And you give it the weight that you want to give it. And it can be a pebble of sand that you put on there for that aggravator, or it could be loaded in dump trucks full of gravel for that scale. And then you're going to listen to the aggravators, and we've elected on 4 different aggravators in this case and that you're going to hear about. And at the conclusion of that, you're going to hear about the mitigators, and that's going to go on the other side of the scale. And I talked to you about this in the beginning, that if at the end, if you look at that scale and the things you've placed on it for the aggravators and the things that you've placed on the mitigators, if the aggravators outweigh the mitigators, you shall impose the death penalty. And we talked about that individually in voir dire, and you all said that you could understand your oath and that you all could do that. And so I want to talk briefly about the aggravators in this case, because we have talked about. Let me spin this around. In the case in chief, which is the first part of this trial, we call it the case in chief, like I said, we talked about the crime itself and responsibility for what his responsibility and roles were in the crime in what happened to Jennifer. And in that, what gets lost in that is that the state is prosecuting the defendant, but the defense is also prosecuting Rebecca Dishman, which causes us, like I told you in voir dire, to plug your nose a little bit, because you have to defend a criminal. And we had to do that in this case. But what got lost in all that was Jennifer Paxton, because we're busy defending Rebecca Dishman and forgetting about and talking about and focusing on what happened to Jennifer. And so that's what this part is about. The consequences based on the type of homicide that occurred. This wasn't a drive-by where somebody was shot in their driveway, which are heinous in and of themselves. But this case has aggravators that deserve your special attention. And the first aggravator that the state is electing upon is the torture aggravator. And at the conclusion of the case, obviously, at closing argument, we'll talk about more specifically, but you could probably see or probably think and enumerate in your mind why this murder deserves special attention due to that aggravating factor that she was tortured. You probably think of all the things that were done that were proven and talked about, being kept for 4 days, etc. But in the end, when you look at that, that's not saying that the defendant did that. That's saying that the murder in and of itself was especially heinous, atrocious, or cruel in that it involved torture or serious physical abuse. And it's our position that our case in chief, the evidence you already have before you, satisfies that beyond a reasonable doubt that she was tortured. And if you find that, you take that and you give it the weight that's appropriate, and you're going to set it on the scale. The second factor that the state is electing upon is avoiding arrest. And you think about the circumstances in your mind. Was the murder committed to prevent the lawful arrest or prosecution? And you think about the circumstances of how this homicide occurred and why the actual death occurred. And the state is putting that in through its case in chief, that in fact the reason and part of the reason, even just if it's a little portion of the reason that they killed her, was to avoid scrutiny of the police and potential prosecution. That is a factor that you can consider as an aggravator in this case. And you're going to assign it a weight, and you're going to put it on the scale. The third factor the state is relying upon is the defendant had a substantial role in the underlying felonies. And your verdict already says he's responsible, but now the nuance is, did he have a substantial role in those underlying felonies? Think about the aggravated kidnapping. Did he have a substantial role based on the information you have in your case in chief in the kidnapping? And you think about and enumerate in your mind, and we'll talk more about that in closing, about why we think that's proven to you beyond a reasonable doubt. And you take that and you assign it the weight and you put it on the scale. And finally, the fourth enhancer that we're going to, or aggravator that we assert that the defendant, we've proven in our case in chief, is that they mutilated her body. And you're going to take that, and if you believe that beyond a reasonable doubt, that he cut her nipple off, her nose off, portions of her arm, getting her from the fridge, putting her in the freezer in the first place, then you'll take that as an aggravator, you'll assign it a weight, and you'll put it on the scale. And all of those aggravators will weigh up to something, and then you're going to find the mitigators, and they're going to present the mitigators, and you're going to put that on the scale. And then you're going to look at it. And it's the state's position at the conclusion of all that you're going to find that those aggravators far outweigh the mitigators, and you shall impose death. Part of the process is that we have just like we did in the first trial, we call witnesses to establish those factors. We're not going to call any witnesses. You've already heard from them all. So our case in chief will have, essentially in this part of the trial, we'll have what's called victim impact statements. And you're going to hear from Jennifer's family, and they're going to tell you how much they miss her. You can't use that as an aggravating factor, but a consideration. But at the conclusion of that, when we get to the end, when you weigh that scale against the mitigators, it's the state's position, and we will ask you to find that you give him the same amount of mercy that he gave her. Thank you.
Thank you. Counsel?
Oh, that was nice and short and impactful. Did I miss number 4? I wrote them down. Torture, avoiding arrest, mutilated her body. He's presenting all the aggravators, right? Oh my goodness. Thank you all for being here. Johnny said, too bad jury can't put the child offenses on that scale, right?
Thank you, Judge. Morning. No, you haven't heard much from me in this trial, but we spoke, I think, back in June when we all got to meet one-on-one. Nobody remembers back that far. I've been driving in every day on this case down Clinton Highway. I'm based out of Knoxville. And right when you come over the county line and you're coming down and Lambert's is on your right, there's a big billboard on your left. It's got a picture of Dolly Parton on it. And it says, find the good in everybody. Find the good in everybody. And thought about it, and it just kind of hit me one day that that's what my job is in this portion of this trial, and that is to investigate and collect documents and talk to people and meet with my clients, and then try to prove and present the good that is in Sean Finnegan. And it's probably a difficult task, I realize, and it's difficult for you all to consider after all the things you've heard in this case over the last week or so. But that's part of my job duties, and honestly, it's an honor for me to represent him through this process. So that's my job. Your job is to decide one issue, and that's whether to sentence Sean Finnegan to death. That's it. It's the one thing you have to decide in this part of the trial. It's more complicated than that. There's a lot of legal standards, and it's a mini trial, and there's witnesses and all that. But if you can distill it down to its essence, that is why we're here. That's what you're here to decide. So I want to start with acknowledging a few things. I understand that some of you may have concerns about your verdict in this case. And I can assure you, based on the verdict that you all returned yesterday, that Sean Finnegan is never going to breathe free air again. Period. He's never going to get out of jail. We've talked about the sentencing options. We'll talk about them again, that you'll have at your disposal today through this process. And we talked about them in jury selection, and of course one of them is life imprisonment, courts have told you before. I know we talked about that in jury selection, and we didn't talk about it in the guilt phase, and now we're talking about it again. But the minimum is 51 years. Okay, he's 56 years old. He turns 57 next month. So do the math. He's never getting out again. The other thing I want to say is that we accept your verdict. I'd be lying if I said that we didn't disagree with some things, but that's just me doing my job for my client. But you all have worked very hard in this case. You deliberated. It's a secret proceeding. I don't know what went on back there, but I just wanted to say that that we appreciate the conscientious decisions and the hard work that you all put into this, and we accept the verdict that you all have rendered. Now, this is the sentencing phase. It's a different task that you have. It's a different trial. Trial within a trial, mini trial, you hear less expressions. But normally, the judge sets a sentence in a case, but this is a very special circumstance. So I want to give you some general principles, if you will, to maybe guide you through this process. Protect society. We've talked about that already. I'm not going to beat it to death. Sean Finnegan is never going to get out of custody again. Punishment for the defendant. That's what we're here to figure out. To serve justice. And to follow the law. Now, where does the law come from in this case? I think we all know laws are passed by our General Assembly, the legislative branch, our state government. And our elected officials have decided that in this very unique circumstance, in a criminal case like this, that you, the jury, should have three options. We've talked about those. Life imprisonment, life without the possibility of parole, or a sentence of death. Three options. I'm here to tell you that the law is satisfied with a life sentence. The law is satisfied with a life sentence. And in fact, a life sentence in this case follows the law, it promotes public safety, and it provides punishment to Sean Finnegan. He's never going to get out of jail again. The sentence of whether to impose death is a choice among alternatives. But I want to remind you that it's not some foregone conclusion. The state, a moment ago, got up and talked about putting things on a scale and weighing things. And the court will instruct you. Yes, you are supposed to weigh things. But this is not some rigid, rote, mechanical process. This is not some metaphorical scale where we get out and we put 6 chips on one side and 4 on the other, and presto changeo, sentence of death. Boom, easy, done. Pull a lever. That is not what this is about. And I know you all have been here a long time. I know you've been away from your families, friends, and your life, and your job, all those things. But I cannot impress upon you the importance of not falling into some mechanical view in this process. The state talked about oaths. And I can't remember how many oaths you all have taken throughout this process over the past couple of months, but there's been a lot. But if you remember back to when we were doing individual jury selection, you all took an oath and you took time to fill out those questionnaires, which were very helpful to us, to talk about very personal parts of your life and personal opinions about serious topics like capital punishment, the criminal justice system. And you took an oath that you could meaningfully consider all three options. Not just whether you could meaningfully consider a sentence of death, but that you could meaningfully consider all three options. And each of you said you could. And each of you are here for a reason. This is not random happenstance. We went through a very lengthy process to select, both from the state and from us, to select you all to serve on this jury. And you're here for a reason, is my point. The law does not recognize automatic death penalty. That's not what this process is about. So I just want to remind you, the law is satisfied with a sentence of life. Next, I want to recognize the loss that Ms. Paxton's family has suffered. The state brought up an opening, and I think it is a good reminder that a great deal of this trial was focused on the power dynamics between Rebecca Dishman and Sean Finnegan. But I'm here to say that it's a tragedy what happened to her. It's awful. We're not here to blame her for anything that she did or didn't do. None of this is her fault. And so I just want to make that clear. Her family through this process, everybody's been very respectful, and I wanted to show them respect as well. But my job, hopefully, is to humanize my client, and I know that seems difficult based on some of the evidence that everybody's reviewed in this case, the lifestyle, the behavior. But I'm here to hopefully emphasize some positive qualities that he possesses. There will be some negative things as well. Our proof will consist of Jennifer Miller from the Pine House again. I wanted her to come back and just talk briefly about his job duties while he worked there, because Sean has worked for, he's 56, he's worked for 40 years of his life consistently. So I just wanted to bring her back to talk a little bit about some of his work responsibilities and what he did there. But the bulk of our proof, our evidence, is going to be in the form of testimony from a family member of his, Miss Roxanne Mundy, who is, there were 6 children in the Finnegan, that generation of children, John's brothers and sisters, so he's one of 6. Many of them have passed away. But Miss Mundy is his oldest brother's ex-wife. Sean was raised in Deerfield Beach, Florida, outside, just north of Fort Lauderdale, on the Atlantic side, in between Pompano Beach and Boca Raton. That's where he's from. He moved around some early as a kid, but that's where they settled. And so Roxanne is going to be able to give us not only her knowledge of the family dynamic of the Finnegan family, which is pretty dark, but she also has eyewitness. She lived in the house for about a year when she was pregnant with her first child. So she's going to give you some insights into what things were like there in the Finnegan home. But if I could sum it up, I would say that Sean Finnegan's formative years, his childhood, adolescence, teenage years, there was a lot of damage, there was injury, there was abuse, and none of which he had any control over. And we're offering this not as an excuse. Okay, I want to make that clear as well. I'm not saying that he's justified in doing what he did in this case, or that somehow it's excusable. I think that's an easy cliche, and I think it's kind of cheap. And so I just want to reinforce that we are here simply to explain who he is, because it's important. If you are going to vote whether to sentence someone to death, I think it's important to know a little bit about who they are. I think you want to know something about him, because he sat over here quietly this whole time. He didn't testify in the guilt or innocence phase, which is his right, and there are reasons for that. I don't know if he's going to testify in the sentencing hearing or not, but regardless, I think it's important that we present some information on who he is. And it's also important to show and perhaps differentiate between what many of your all's childhoods were like. We didn't get into that granular level of detail in your jury questionnaires, so I don't know what everyone's walk in life has been, but I think that most of us were raised in a home with love and protection and dignity and guidance and respect, and he didn't really have that in the Finnegan house. So I think we all can agree that children start out basically the same, like a blank slate, and through twists of fate and other decisions and actions that are out of our control, our lives can end up remarkably different. And especially as it relates to a history of sexual abuse and the trauma that he suffered, I think it's important to show that he didn't have any help, he didn't have anybody there for him to support him. His mother, Frances, with 6 kids, and the behavior of his dad, John Sr., Big John. I think poor Francis was just trying to make it day by day. And I think Sean and some of his other brothers slipped through the cracks. And I try to think of it psychologically or even emotionally. And I've got a toddler at home. We put up baby toys a couple of months ago in one of those hammer sets where you push down and one pops up on the other side of the board. And I think that's a good analogy for the psychology or the emotion of what dealing with trauma is like. That I think Sean, things happened to him, which we're going to talk about. It's not pleasant, but I think that he buried it deep down and tried to lock it away. And it came back out in other ways, in not healthy ways, with violence and risky behavior and toxic relationships and poor decision making and substance use. So I think that's important to remember. As the state mentioned, yes, there are going to be the legal principles of this process are presentation of aggravating circumstances and presentation of mitigating circumstances. And so our mitigation is going to be basically a variety of instances from his childhood, the things that he experienced, what his family unit was like, sort of the foundation of his life, and why perhaps he may have, why we're all sitting here talking to each other. Maybe some explanation for that. But ultimately, I want you to remember that aggravating circumstances are a reason to impose death. Mitigation is a reason to vote for life. And at the end of this small trial, I'll get back up and I'll be advocating for a sentence of life. Thank you.
Thanks, sir. State recalls first witness.
Your Honor, victim impact statements will be read at this time. And
Okay.
I don't know if the court wants to address those in a particular order, or if you want
Let's see the first one I've got.
Okay, whoa, let's just take a pause. Lupo Nina said, let's be honest. Most people have come from some kind of dysfunction. Families have issue. We cannot excuse these crimes by that 100%. Does it factor in? Yeah, if we were studying the psychology and all that. But does it factor in? I don't know. I know the attorney's just doing his job. Let me say the disclaimer. I understand it. He's doing it well. It's just so difficult, especially, I don't know, there's so many people in this community that have been through some stuff, right? And so, are you going to apply yourself? Are you going to have empathy for others? Are you going to say, oh my word, I've suffered so much, so therefore I'd never want someone else to suffer like that? Or are you going to take it and inflict incredible abuse and trauma on others? Like, what the hell, man? That's a choice. At the end of the day, when you're an adult, that's a choice. That's where the empathy ends for me. I've said it before. I wrote 4 books, right? One was on Jeffrey Dahmer, one on Ted Bundy, John Wayne Gacy, and Eileen Wuornos. And all of them have trauma in their background. And it's like, shame. We could feel sorry for, let's say, the child, the boy, John Wayne Gacy. Oh, but the minute that guy decided to start abusing and then killing people, no, man. Empathy, line in the sand, empathy in the box, that's where it ends, right? Oh my goodness. So it's going to be difficult for us to hear. I'm just going to say that. I'm warning us. I'm warning myself as well. It's going to be difficult to hear all the sob stories about Sean Finnegan. People have been through a lot in life. There's a lot of people. There's actually not that many homes percentage-wise, I don't think, that are like loving and, as the attorney said, have dignity and love and protection. I don't know. Maybe we're just jaded because of the true crime, but I just think it's going to be difficult. That's all we know. Now it's going to be victim impact statements. That in itself is going to be heavy. So make sure that if it gets too much for you, that you look after your mental health, take a break, come back. We will always save you a seat, okay? If you ever want to just take a break, just know your seat is saved. You can come back. So let's see who the first will be from. So these are now the official victim impact statements in front of the jury. The others were what they would normally do in chambers like they did the other day. It was what I call the practice round. The judge actually said something like that. So it was sort of just to see if everything that they're going to say is allowed in. And that's just part of the legal process. And so now we're going to see it for real.
should have 4 total.
Beverly Jeffers. Ms. Jeffers, if you'll step up here, please, ma'am. Would you have a seat up here at the witness stand for me, please? You'll raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Okay.
Thank you. There's your victim impact statement.
Thank you.
If you'll read that to the jury, please.
I'm sorry. Your Honor, I want to thank you for allowing me to speak on behalf of our family. Our lives have forever been changed. It is always hurtful to lose someone you love, but it's a different kind of hurt and pain to lose someone you love the way our family lost Jennifer. We didn't just lose Jennifer, she was taken from us. When Jennifer went missing, we looked all over town for her. Gail, Mill, and David and Brittany looked on the south side of Knoxville. The rest of us looked on the north side. We looked for her not just for a day or two. We looked for her for months, day after day. Her grandmother, who she called Mom, would call me almost every day to ask if I had seen Jennifer. It was so hard on us. We knew Jennifer wouldn't go for days and not contact Mill or one of us. Then on August the 6th, 2020, Patty, Jennifer's mother, received a call no mother should ever have to get. They found Jennifer. Patty was so devastated. When she called me, I couldn't understand what she was saying. Then when I finally did understand, I, like the rest of our family, went into complete shock. The most awful thing that could happen to a person and their family did happen. Jennifer was murdered. Jennifer, who was a mother, a daughter, a granddaughter, a sister, a niece, and a cousin. Her mother, Patty, didn't make it through the loss and devastation. She died with a broken heart before Patty passed away. She asked myself and the other ladies here with me today to promise her we would be here every day in court for her and Jennifer to show Jennifer was loved, is loved, and forever will be loved and missed. Thank you.
Thank you, ma'am. I'll have that back, please.
Shame.
Thank you so much.
Thank you for all the purple hearts for
Then
Jennifer.
next I have...
Shame. We actually saw her read that, remember, in front of the judge when the jury wasn't in the room. That now the jury was there. That was, oh man, she was so strong to do that. Oh my goodness. So, okay, let's see who else will have their victim impact statements now.
Okay. Do you have any questions? Any questions from the defense? Okay, thank you. Then next I have, is it Brittany Payne? And I think Miss Payne is going to read hers, but she's also going to read her grandmother's. Is that correct? And your grandmother's name is Mildred Corbin.
Yes,
Correct?
Mill.
Okay. You'll raise your right hand, please, ma'am. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you. And then obviously anything that I do will learn to do, don't need to read. Okay? Please say your first name and last name and spell them both for us, please.
Brittany Payne, Brittany Payne.
Thank you, ma'am. Go ahead.
Jennifer.
Is this yours or your grandmother's?
Mine.
Okay.
Jennifer was my first cousin, but we grew up as sisters. I love Jennifer with all my heart, and losing her has really hurt me. I can't think straight. I have nightmares. I can't sleep right. And this past week, I can't even eat right. I can't even listen to songs without thinking of her. It hurts me to know that I'll never see her again. I'll never hear her voice again, or see her smile, or hear her laugh. It absolutely kills me that I didn't get to tell her goodbye. Knowing I'll never get those phone calls or messages ever again destroyed my heart. My whole world changed turned upside down. I'll never look at this world the same again.
Thank you. And I think this is your grandmother's, correct?
Correct.
And I think she's here today.
She is.
Okay, great. Go ahead.
Jennifer was my granddaughter. I loved her dearly. Losing her destroyed my heart. She was my everything. When Jennifer went missing, we searched everywhere for her. Not for days or weeks. We searched for 8 months. When Jennifer was found, sadly it wasn't the news we were hoping for. When I learned of Jennifer's death, a part of me died as well. I struggle every day. The anger, the hurt, the despair is indescribable. The nightmares that I still live with to this day will not go away in this life. The only thing that helps me get by from day to day is knowing I'll be with her again one day in heaven. Thank you.
Thank you so much. All right. Any questions from the state?
There are.
Any questions from the defense? Okay, thank you, ma'am. You step down. And then next I have, is it Michelle? And Michelle, I think you're the first cousin, right? Okay, step on up here, please, ma'am. And I added that last page like that's me too.
Okay, good.
And then be sure you don't read anything that I've drawn a line through. Okay? If you'll raise your right hand, swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you for having a seat, please. If you'll tell me your first name and last name and spell them both.
Michelle McMahan, MICHELLE, MCMAHAN.
Thank you so much. Now you can read your statement.
I'm Michelle, a first cousin to Jennifer's mother, Patricia. First, I'd like to tell you about Jennifer. She was kind and loving, and she cared about other people, even strangers. She grew up with a tough life, as many of us did. The difference between her and us is that she never seemed to make peace and get past the hardships of her childhood and upbringing. She never knew her natural father, and partially, I think that gave her a distorted view of what a typical family unit should be. I believe this led to her making a series of poor decisions in her own life, including the men she chose to try to build a family with. She longed to have a typical, normal American family, but she trusted too easily and too much. Jennifer's mother tried the best she knew how in raising Jennifer, but in her own words, she made a ton of mistakes, especially with Jennifer. Patty was desperate for Jennifer not to make the same mistakes that she did herself, like becoming a mother at just 15 years old. Because of this, she was way too hard on Jennifer, not allowing her to have normal friends. She wasn't allowed to play in the neighborhood like her brothers or hang out with others after school unless it was with family. This is why Jennifer so lovingly clung to her grandmother. She felt loved with her. She was allowed to be more of a child with a normal life when she was with her. So naturally, Jennifer had more of a mother-daughter relationship with her than she did her own mom. Jennifer was also the middle child and the only girl to her mother, Patricia. When Jennifer went missing, it didn't go unnoticed by our family. Even though she had become part of the homeless community, many of us searched for her for months as we looked at every person we passed as we went about our daily lives, hoping to spot her somewhere, as we always had in the past. Patty, like many other parents of addicts, was terrified of getting that call or knock on her door to tell her that Jennifer had overdosed and was gone. I spent much of the time after Jennifer went missing with her mother until her passing only 16 months later. She suffered finding out about Jennifer's demise after 9 months of searching. She blamed herself. She stated and questioned regularly how if she had been a better mom or if she had tried one more time to help her, if she could have prevented what happened to Jennifer. She thought Jennifer fell victim because maybe she didn't feel loved enough or because she had been so hard on her in her life. Patty died in the hospital, still crying and suffering over what happened. Patty had battled health issues for many years, but after losing a second child, she had just given up. She was tired of the regret, tired of the nightmares and the day thoughts, tired of suffering and missing her daughter, Jennifer. Our family would just like to say that Jennifer was not a prostitute in the terms that one may think. She was a desperate, young, addicted woman who was offered drugs and a place to live in exchange for sex.
Please. Any questions from the state? Any questions from the defense? Thank you, ma'am. You can step down and freestanding court, we're free to go.
Madam Clerk will mark that as sentencing ID number 1. And it's just for ID. It's not made an exhibit.
Yes, sir.
Let me get together for you.
Yeah, I was just going to say, some people are still upset that some of the sentences were taken out of their victim impact statements. But I mean, you don't want a mistrial based on, something being said directed towards the defendant, because that's not how it works. That's not allowed for victim impact statements. If they did that, that could be grounds for an appeal or grounds for a mistrial from the defense, of course. And this, it's a death penalty case. So they have to do everything correctly. They have to follow the law. And as Pernille says, it was the judge's ruling to remove small things from the victim statements to ensure a fair trial. The family members understood. Yes. And most of their statements were still in there, right? Okay. So by the way, I understand why people feel upset, but facts over feelings or rules over feelings in the courtroom, right? There's procedures to follow. As much as we wish that they could just completely express themselves. Do you guys remember at Jeffrey Dahmer's trial? That one of the victim's sisters, that's the way that she addressed Jeffrey Dahmer, that was classic. I'm a word and shame. So painful, but I'm just whoa, one would wish that they could say that, but unfortunately they can't. So
And any additional proof by the state?
No, Your Honor, state rest.
Thank you. And for the defense, who will be your first witness?
Please, we call Jennifer Miller.
Miss Miller. So we need to get Miss Miller.
She's outside the hallway, Judge. I'm glad to pick her up too.
I think the deputy will get her for me.
I'll get her. My co-counsel.
Okay.
wow. Okay, so the state has rested. This is the sentencing phase, okay? The state has rested. They presented all their aggravating factors. They're not going to have any witnesses. They're confident in their case. Now, the defense is going to have, I think they said 1 or 2 witnesses. The first one being Jennifer Miller. We heard from her before. I think it's the lady. I'll correct it if I'm wrong, but from my memory, it's the lady who used to work with Sean at the Pint House, okay? So
Yes.
You go to the restroom? Okay. We'll take about a 5-minute break. Let's go step down and go to the restroom. Two officers, y'all need to go? Okay, so y'all stay with me. Okay. All right. Stay rise, please.
Okay, we got a 5-minute restroom break. Teleporting. Ready?
Thank you. Y'all can have a seat, please. And I'm just going to sit here and we're just going to wait until they come back.
I'm just gonna go too.
Sure.
Okay, so now we're gonna skip over this. What is happening? Okay, they're back.
Thank you. Have a seat. Ma'am, if you'll raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you. If you'll speak up and if you'll say both your first name and last name and spell them both.
Jennifer Miller, JENNIFERMILLER.
Direct Examination Counsel.
Judge, good morning, Ms. Miller. Thank you for being here again in this process. We heard your testimony earlier in this trial. Can you remind the jury again when you worked at the Pint House in Knoxville?
From January 2019 until July 2024.
Okay. And when you were working there, what was your position?
I was a manager.
Manager. Was that for front of house, back of house, general manager? How would you describe it?
I was the general manager at first. I was an assistant manager before that.
And so were you responsible for hiring and firing employees?
Mm-hmm.
Did you hire Sean Finnegan?
No.
Okay. He came on. Describe when he worked there, his time period.
There was another manager that we had that hired him, and he was our cook, and he usually worked 5 to 7 days a week. Came in at 5 o'clock at night. Pretty much always showed up on time. Came in when I called him in. Stayed after and cleaned the floors for us.
What would a cook's job duties be at the Pine House at that time period?
Just prepping and cooking, really. Taking out the trash, maybe.
Would somebody that came on at 5 p.m., would they be doing a lot of prep work?
Yes, we only have the one shift, so 5 o'clock is the open to close, yeah.
Okay. And how many cooks would be on the line, typically?
Just one at a time.
One at a time?
Mm-hmm.
What kind of cuisine did the Pine House serve at that time?
Just bar food,
Bar
fried
food.
stuff, burgers.
And was there, did the service ramp up at a particular time of night or morning or late night? Was there a rush? It's a better way to ask it.
Sometimes, maybe like 8 to midnight.
Okay. And how many tables were in the Pine House?
I don't know. Several. We didn't do table service. People just would come to the bar to order.
I got you. So they would order food at the bar?
Yes.
And it would be brought out to the bar?
Yes.
Okay. Okay, so one cook is doing all the cooking. How was the kitchen, large or small, or how would you describe?
It's small.
Small kitchen. Okay. Do you know, this is kind of out there, but do you know what his pay would have been at that time?
I don't know.
Do you think he was paid hourly or salary?
Hourly.
Okay. Okay, and so you testified a minute ago, and I think already previously at trial, that Mr. Finnegan worked 5 to 7 days a week. Is that what your testimony was?
Yes.
And you had an opinion that he was reliable, is that right?
Yes.
Okay. Can you describe what that means in the context? You know, why is it important to have a reliable cook in a restaurant? Can you describe that a little bit?
There's a lot of turnover. People, they come, they stay for a while, they quit, or they don't show up to their shifts, or they're late frequently, or anything like that.
Was Mr. Finnegan, did he have a lot of no-call, no-shows, or?
Rarely. Very rare, yeah.
Okay. Does the cook also wash the dishes?
There's a dish machine that they just get run through, yeah.
Hobart machine?
Mm-hmm.
Yeah. I remember. Okay. And as far as Mr. Finnegan's attitude and demeanor with the staff, how would you categorize that? Or characterize that, excuse me?
Generally pretty normal. We joked around a lot. It's a pretty laid-back job.
Okay. Pass the witness, Judge.
Question?
No, Your Honor.
Thank you, ma'am. You step down. You please say the ball. There you go.
Thank you.
Who's next?
Roxanne Mundy, Your Honor.
Okay, so next is Roxanne Mundy, who I don't know if they're going to say it all again, so I'm rather going to say it now. They said it's Sean Finnegan's oldest brother's ex-wife. And Kristen Pino says, please ignore the horrific things that this monster did because he was a cook and a dishwasher. Okay. And he was very punctual and 5 to 7 days a week. Like, oh dear. Okay, so I think I don't think they have more witnesses after that. Let's see. Roxanne Mundy, here we go.
Deputy, would you get her for me, please?
Okay, let's see if we can go forward a bit. Yeah, okay. Look how he watches.
Right here, please, ma'am. Good morning. If you'll raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you. If you have a seat, please. If you'll tell me both your first name, you have a seat. If you'll tell me both your first name and last name and spell them both for me. And if you'll speak up in the microphone, that'll help everybody hear. Okay? All right, your first name and last name and spell them both.
My name is Roxanne Mundy, RoxanneMundy.
Thank you. Questions?
Ms. Mundy, welcome. Where do you live currently? You don't have to give your street address, but generally, where do you live?
In Indiana.
Okay. And how old are you, ma'am?
61.
Are you, who do you live with?
My husband.
Okay. Do you have children?
We do.
Okay. How many biological children do you have?
2.
Okay. And are there stepchildren as well?
Yes.
Okay. How many stepchildren?
We have 4 other daughters. 4.
Okay. Do you work outside the home currently?
No.
Okay. Historically, did you work in a particular field?
Yes, always.
And what was that?
Mainly restaurant work and construction.
Okay. Do you know Sean Finnegan?
I do.
You recognize him sitting over here?
Yes.
When's the last time you saw him?
Well, it's been probably about little over 3 decades. Personal.
Mm-hmm.
Yeah.
Okay. At some point in your life, did you meet his older brother,
Yes.
John Finnegan Jr.?
Yes.
Describe how that occurred, please.
We were dating. We met each other, and then we were married.
Okay. Where did you all meet? Where were you living?
We met in a restaurant. We lived in separate places while we were dating, and then later past that, then we moved in together.
Okay.
When we were engaged.
What state were you living in?
Florida.
Okay. Which part of Florida?
Fort Lauderdale.
Okay. Is that where you were raised?
Yes, that's where I was raised.
That's where you grew up?
Yes.
Okay. How old were you when you first met John Finnegan Jr.?
Early 20s, 21-ish, 22.
Okay. And when you first met him, were you dating immediately, or was it just an acquaintance at
Well,
that
we,
point?
of course, talked and spoke on the phone. Back then we didn't have the technology we do now, so it would be a phone call or something like that, and then a lunch or a dinner or a walk on the beach kind of thing. And then as we get to know each other, we did that often until we really knew each other.
You were dating?
Yes.
When you were first dating John Jr., did you meet any of the other family members at that point? Did he introduce you to them?
Not right away. It was probably about 6 months or so that he introduced me to the family.
Okay. And describe for the jury your first impressions of the Finnegan family.
Well, the father was quite fearful. I did have very uneasy feelings. The children seemed to be even afraid of their father, like very meek, quiet. The mother, Frances, was very kind and soft-spoken, but also had the same appearance of perhaps fear of the husband. It seemed like he controlled what people did or said within the home, and if they were allowed to, like, really, say anything, or, maybe if they got out of line, because he was very aggressive.
When you first met John Finnegan Jr., what was that interaction like? Excuse me, when you first met John Sr., Big John, what was that interaction like?
I was terrified of the man. He said horrific thing, like your first greeting with him as a female. He was not kind.
Inappropriate?
Inappropriate, very inappropriate.
Okay. So what about Mr. Sean Finnegan? Do you have any, like, when you first started dating his older brother, did you have any initial interactions with him or takeaways or memories?
Just that he might have been a little afraid and a little shy to come out and really be out there, as, most families. I took it as just a new meeting, with the children, and children can be giddy because his other little brother and sister were also in the home, and they were your typical kids, but still, like, what I would say, like, is if you were to stifle a child and not allow them to interact with guests, perhaps, go to your room, don't come out, kind of thing from his father.
Well, let's try to identify the children in order. So, you were early 20s. You first started dating John Finnegan Jr. Mm-hmm. How old would he have been at that time, the oldest brother?
If I was 22, he was 24.
Okay. And the next youngest brother below him is who?
Would have been Edward.
Okay. He went by Eddie?
Eddie.
Okay. How old was Eddie at that time? Approximately, if you know.
He would have been 20, I think he was just a year under John.
Okay. And then after Eddie, who was next?
And then Jimmy.
Jimmy.
Or no, I'm sorry, Sean.
Okay. How old was Sean at that time?
In his early to mid-teens.
Okay. And then next was Jimmy?
Yes.
And how old was Jimmy?
Young teens, mid-teens.
Okay. And then after Jimmy, who was next?
Colleen.
Okay. How old was Colleen?
Maybe 10-ish, 11 maybe.
Okay. And then the youngest was who?
Danny.
Danny. And how old was Danny?
7 or 8.
Okay. All right. So at some point, did your relationship develop with John Finnegan Jr.?
Yes.
Did it progress, I guess is a better word.
It did.
Okay. And without going through the entire relationship history between you two, but can you just describe for the jury how that progressed and that led you to end up moving in with the Finnegan family? Describe that for them, please.
Okay, John and I, dated until the time we thought that we would really like to spend our lives together and be engaged and get married and create our own future. He was very much different than the rest of the family because he pretty much had moved out earlier, so he didn't have what was going on in the home in his life, and he really didn't want to go there much. And then we decided to move in together. I lived in a townhome. He lived with a friend. And then we decided we were going to start looking for an apartment. We did that. We moved in together. We had a roommate. And then I found out I was pregnant. His mom had come over. We tried to have his mom with us as much as possible. And so one day I was not feeling well, and it kind of progressed a little bit for a little time where I thought maybe I better see my doctor and have a test, and found out I was pregnant. So then we had to, make a bigger decision, being engaged and then getting married and all that. So we did. Through my 4th month sonogram, there were a little complications with the pregnancy. So the doctor said that somebody would have to be with me all the time and be slower or bed rest. I was always a very active person. Bed rest wasn't going to work for me. So we decided to speak to Sean's parents, and because of the house being so large and everything, there was a nice big back bedroom that we were going to move me into. So here we had to go again, get folks, and we moved in with his parents and the kids until after my pregnancy. And then after we had baby, maybe 2 or 3 months later, we were able to actually go back and get into our own place again.
Okay. Before we launch into the family and the home, as you became integrated in their family, did you learn about how the Finnegans had come to live in Florida?
Yes. Later, some things are hard to talk about for others, but later on, and after comfortable conversations were easy to come by, John had let me know that when they moved here, they had to move in a hurry from where they were living in Ohio, had to leave everything behind. They ended up in a car in a rest area, and that was in Florida, in Pompano or Deerfield. And they're very close together, so it's kind of almost one big city. But they lived in a car. Their father went to work. My husband went to work with him, and the other children, the boys, were supposed to go to family uncles, and I don't know that they were really biological family uncles because I never met that side of the family. That's what I was told. So, and then Colleen and Danny stayed in the car with Frances, their mother, in the rest area. And that's pretty much the basis of how they started out.
Do you know how long they lived that way?
I understand it to be quite some time. It could have been anywhere from 6 to 9 months.
And that was while they were trying to get money together to get a stable
residence.
Right,
to save money to get into a place.
All right, so when John Jr. went to work with his dad, was he still of school age? Was he still a juvenile?
Yeah. Mm-hmm.
Okay.
I think he was 16 when it happened.
And so did he go back to school at that point?
No.
So he dropped out?
Yes.
And what kind of work did the father do, Big John?
He was a butcher.
Okay. And so what kind of work was John Jr. doing with his dad?
It was a supermarket that they worked in, so he did like shelf work, stocking, sometimes wrapping meat. But basically, the groceries, just putting everything out.
Okay. All right. the family eventually found a stable residence in Deerfield. Is that right?
They did.
Okay. Describe what the house looked like, or what kind of place was it?
The house was beautiful, large, very open. I mean, just your Florida. I don't know if anybody here knows much about Florida, but the homes are built very large, very tall ceilings, very strong, beautiful architecture, and the rooms, of course, like when you walked into their home, it was a living room, kitchen, dining room, kind of huge open area.
Okay, I gotta put a disclaimer because I'm like, yeah, butcher father makes sense in this context, of course. No one's shading all butchers in the world and all of that. Okay, butcher father, based on what Sean Finnegan did. Oh, interesting.
So who actually bought that house?
Eddie did. Their son, Eddie. The second to John's, under John.
So how old was Eddie?
He was in his teens.
So a teenager bought a
elder
house.
Teen, yeah.
And how do you think he came into the money to be able to do that?
He was working for some Italian people that probably weren't the nicest type of Italian people.
I understand. So you moved into that house eventually, is that right?
Yes.
Okay, so when you moved in, who all was living there?
Oh, Sean, Danny, Colleen, Francis, their grandfather, their father's father, who was a war veteran, John Sr., the father, myself, and my husband.
Okay, and so Eddie and Jimmy were already out of the house?
Yes, Jimmy was on his own at an early stage. I mean, Eddie was on his own. Yeah. I'm sorry, Jimmy, I wasn't quite sure.
Gotcha. So, how old was Sean when you moved in to live with them?
I would say 13, 14.
Okay.
School age, middle school age.
What was his demeanor like?
Giddy, funny, typical teenage boy. But kind of stayed to himself in his room all the time. And that his room was, it was dark. It was, like headbanger music, heavy metal, mm-hmm. if you will. Darker walls, just kind of to himself all the time.
Okay. Was he going to school at that time?
No.
Do you know why?
Well, he was supposed to. And there were times that him and his brother walked to school, but there was a truancy officer that came to the house one day and wanted to know why they weren't in school because they had missed so many days. And it ended up that it wasn't because he was skipping school. He was going to uncle's home who was picking him up with his brother.
Okay.
And
well, okay. Before I get to that, if I could have just a second, Judge. Now, first witness, Judge. Ms. Mundy, have I provided you some of, first of all, can you identify this packet of documents I'm handing to you?
Yeah, these are Sean's school records.
Okay. And have I provided that to you for you to look over?
Yes.
In preparation for your testimony here
yes.
today? I'm not asking you to quote from them, but based on your general knowledge of his lack of attendance at school, those documents appear to reveal that he stopped going to school in about the 8th grade. Is
yes.
that accurate to your knowledge?
Yes.
Judge, I'll move to 10 of these as next example.
Copy sentencing exhibit number 1.
Okay, so Sean wasn't going to school when you moved in. Were any of the other children not going to school? Any other siblings?
As far as I know, Jimmy was not showing up.
Okay. Now, before we get to that, I just want to ask you about the general dynamic in this family unit when you moved in, okay? And I want to go down the list. When you moved in, sounds like you had your own room off to the back side of the house. Is that right?
Yeah, pretty much the whole back of the home.
Okay. A place where you could shut the door and kind of have some refuge. Is that fair?
Yeah, it was a large lanai, and we turned it into the room, the bedroom, and the baby's room.
What was John Finnegan Sr., Big John, describe his behavior, demeanor, affect, describe what he was like to be around to this jury?
Awful. Everybody in the house feared him. Didn't know what he was going to be like when he came home. He was a major alcoholic. And then later found out that he was also gambling. He was always very aggressive. If he walked in the door and Francis did not have his food prepared, when he wanted, if he walked in the door, he wanted it on the table.
And if it wasn't on the table, what happened?
Yeah, if it wasn't on the table, and trust me, he pretty much always had a beer or something in his hand, he'd throw it.
At whom?
Her.
At Francis?
Yeah.
Would he throw things at children?
He would, yes, he would. If they heard him, they would run to the room. They wouldn't come out. They were terrified of him. And he was always really aggressive, throwing things around, breaking things, picking up dining room chairs and throwing it. Whoever was there, the children could be standing there, and he would just act like that. So it was terrifying, honestly.
Was he, as it relates to Francis Finnegan, you're saying he was verbally abusive to her?
He was always very degrading to her.
Was he physically abusive to her?
Yes. Very.
How so?
Well, the times that I could see is when he would throw things at her visibly, and then there were times he would drag her to the bedroom, and you could just hear the beating and the crying and the begging and pleading of, please stop. You're hurting me, stop it. The kids are going to hear this. It was not an easy feat to listen to.
And as to his dynamic with his children that were in the home, at least, what was that like?
The same.
Abusive?
Very.
Verbally?
Both verbally and physically.
Okay. Did he spare Danny and Colleen, the youngest, or were they all subject to this?
Danny and Colleen kind of got they did hear all of the violence, and they did hear the vulgar remarks, and there were times that, a bottle or a dish or a glass vase or something would miss their head, and they'd go run to the room. But he never, really snatched them up like he did the boys.
And I apologize, I forgot to ask you later, but we don't have to go through all of it, but had there already been an incident before you moved in with them where you heard about abuse between Big John and Francis, and Sean was in the home?
Uh-huh.
That was before you moved in, though? You knew about it?
Yeah. John and I, my husband, ex-husband, we were actually out at an outing by the airport where a lot of us girls and guys got together. A friend came to us and told us that we were needed at home because Francis had been beaten beyond recognition. And it was Sean that had asked somebody to get us to go help. And when we got there, Francis was behind the sofa. And we, I guess he couldn't get her to come out. And when we finally got her out from behind the furnishings, she was beat up so bad. And she didn't want to go to the hospital. She really never wanted to. I cleaned her up. She had a gash in her head that bled, and heads bleed a lot, but cleaned her up, tried to calm her down, and, invited her to our home for safety to keep him away from her, so.
Okay. Thank you. Now, as far as the children in the house at that time, what were their lifestyles like, their hobbies, their interests, peers?
There wasn't really anything. I mean, this is the kind of person you would think, for lack of better words, keep your family as a prisoner, keep them in the home, not allow them sports or normal, everyday things that, children would be able to do. They weren't allowed things like that. No sports, no type of activities.
Did they have friends come over to play?
Never.
Did they go to friends' houses to play?
Never.
Did the family do family things like go to movies or go to the beach, things like that?
No. Their mom wasn't even allowed to wear shorts, even at home.
Did they go to church?
No.
Were they religious?
They prayed to God. They believed in God.
Okay. So, did Sean have his own bedroom when you were living there?
He shared a room with Danny when I lived there.
Okay. And so Danny was younger. In your testimonies, Sean tended to stay in his room and crank up the heavy metal.
Yeah, he was always in a dark way.
Okay. Was he abusing drugs or alcohol?
Both.
Okay. What kind of drugs was he using?
I don't know. They were being administered to him by his uncles.
Okay, we'll get to that, but...
I know that he smoked pot and he drank.
Okay. Did you all get along, you and Sean, when you were living there?
Yep.
Okay.
The kids were, good when the dad wasn't around.
Did he have any other hobbies or interests, to your knowledge?
Just his music.
Music, okay. Okay, we've talked about Frances's life. Did she have any other life outside of the home? Okay.
I hope Danny is okay, the younger sister. She shared a room with Sean. I mean, when they said all the ages, it sounded like she was a lot younger, like 15 years younger or something than Sean. And she shared a room with him, and they're saying Sean's room was so dark and heavy metal all the time, and he was always in a dark way. Oh dear. Like, I hope Danny's okay. Oh my goodness.
What about Big John's social life? What kind of lifestyle did he have?
He was gone all the time, always gambling, always drinking, going to the pizza parlor where Eddie worked.
Okay, so did Eddie Finnegan own a pizza parlor, or did he manage one?
It was a partnership between him and the gentleman that helped him open it and get his start in life.
Okay. Did you have suspicions that was also maybe a little shady?
Yep. I believe so. I wouldn't be able to prove it, but by the amount of money it took to open it and to buy a home and have a mortgage at his age, yeah.
What kind of gambling was, if you know, what kind of gambling was Big John doing?
Anything that he could do, from numbers to the dog races were really big because they were all the time.
Okay.
And then when the horses came.
Okay. Did he ever get punished physically for his gambling debts?
Well, there was a time once that Eddie called and asked us if something, from the house, if any one of us had something done, but went to open the pizza parlor and found his father laying on the ground by the door, all beat up.
Sorry, I'm answering Joe earlier. Joe saying, but wait, what if Danny was a brother? Maybe Danny was a brother. I'm saying from emails I received and counting all the siblings, I thought maybe Danny was a girl. Right? Colleen was the girl, Danny was the youngest boy, says Tammy. So, okay. I hope the youngest brother's okay, though. I hope Danny, is okay. Because it sounded like Danny was only around 7 at the time, when maybe Sean was in his 20s or something like that. So either way, whoever shared a room with Sean Finnegan, I hope that they're okay now. Because, whoa, like living in a dark room with an older brother, it just sounds a little bit scary, right? I don't know.
Okay. At some point, was there kind of a sequence of events that was the final straw of Big John living with the family?
Well, after the beatings and after, the police having to be called all the time because I had Frances get an EPO, protective order. I don't know if everybody knows the abbreviations. Every state's different. But so we had a protective order taken out on him so that he couldn't come near the home, so she could be back in her own home and the children to be safe and everything.
Did he follow that?
No. No. I was there one day.
Okay. Tell the jury about what happened.
Yeah. Okay. The way the house was, the driveway was very long and went up, and the garage was not an enclosed garage. It was the type you could park the car up into, and there was a door. The first door was from the garage. You walked in, laundry room, and then the second door that you walked through was the door that went into the kitchen. So even though he had the protective order against him, he said, it's just a piece of paper, I don't care. He was screaming outside, throwing bricks at the window, banging on the door until he finally kicked the door in. He kicked the first door in, and then he kicked the second door in, and I own pit bulls, and I had Brandy, which was one of them at the time, by my side, because he just came in all drunk and screaming, had a beer bottle in his hand and threw it at Francis's head. And when he did that, I had my baby in my arms as well, and it missed my baby's head maybe by an inch or two, and my dog attacked him. My dog tore him up, and he had to go to the hospital. They quarantined my dog because, I guess that's what happens when a dog does bite somebody, regardless of whether they're protecting the home or not. And she ripped open his side and his hip and half his leg. So at the hospital, there was an officer there. But also at the home with us, there was an officer there. Communicating with each other, the officer in the hospital wanted, something from the home or whatever. And then he was like, the dog, we got to do something about the dog. The officer said he has the one that was with us said he has a protective order. The doors are kicked in. The windows have the big, marks from the bricks because it was a huge double plated glass window. And the dog, was fine because the officer wanted to see if she was aggressive and mean like that, other than protecting the family. And Brandy wasn't. She was, a little marshmallow, but she just, she never liked him really. But
understood. As a result of those events, did the family minus the father, did they eventually move in with you and John Jr.?
Yeah, we couldn't let them stay there any longer. Okay. We had already moved out by that point, and I was visiting. So we had a landlord who had an apartment coming up available. The folks had moved out, but it still needed the painting and maintenance that they do in apartments.
Sure.
And he allowed Sean was at that point with his mother, Colleen and Danny. And so we spoke to the landlord about perhaps helping them with the money for deposits and to get in there. And because of the circumstances and because John and I had lived there so long and were good friends and stuff with them, they let them move in the day the apartment was ready and then worked out a billing arrangement for them to have so that they could, of course, have a place of their own to live where he couldn't find them.
Was Sean working? He was a teenager at that time.
He was working at Burger King.
Okay. Did Frances get a job there as well?
Yes, she did, through Sean.
And was that, I think you told me, was that Frances's first job?
Very first job. Never drove a day in her life. Very first job. She was as proud could be. I've never seen a woman so happy about going to work, and she walked every day. So, yeah, it was something for her.
I know you mentioned earlier, and I cut you off, but we do have to talk about some other serious subject matter. And I didn't mean to cut you off then, but I just wanted it to make sense, at least in my mind. So at some point, you were saying earlier that maybe while the family was living out of their car at this rest area and getting settled, okay, that Sean and his other brother were being watched by some distant relative of John Finnegan Sr.
If they were,
Okay.
I'm not sure.
Okay. Did you later speak with Frances about what was going on?
Yeah, that was horrific.
Okay. Can you speak up a little bit? Can you tell this jury what you and Frances discussed?
Well, Sean came home one day while he was supposed to be coming home from school. It wasn't school he was coming home from. And he was a hot mess. He just walked in his room, closed the door, like in desperate, like didn't want to cry, but just couldn't handle the pain any longer, and told his little brother that he was being abused by the uncles, sexually abused. and made to do things, against his will, what he didn't want to do. And I mean, it was just horrific for someone to take, a child, making them do things and laying them on their bellies and beating them and having sex with them, having other people have sex with them. And brutal, not, nothing like a fantasy. It was an awful experience for him.
It was he and his brother?
Yes.
Both of them?
Mm-hmm.
And how long did that go on?
I don't know how long it went on, because I don't know how long they had to be there with the uncle first in the beginning, but it didn't go on long after the truancy officer came to the house.
Okay. And you also learned that later in time. Sean discussed that with you some, right?
Years later, okay, when we were working together.
Okay, we'll come to that. Working together. But so the sex abuse went on for several months, and were they also being plied with drugs and alcohol?
Yes.
Okay. And eventually a truancy officer comes around, basically, hey, these boys are not going to school. Mm-hmm. And so now, is that when Francis became aware of what was happening?
Yes.
Okay. And what happened as a result of Francis and Big John finding out about this truancy officer?
Okay. Truancy officer comes to the house. He was not there at the moment, but Francis took the paperwork he gave her, told her that if the boys weren't going to start showing up at school like they were supposed to, they would be kicked out of school. They would not be able to go to that school anyway. And so she had the paperwork. Her husband, John, came home. She discussed it with him briefly, and he took the paper, and he beat Sean into oblivion. He could hardly walk. He went in his room. He couldn't even go to school for a week after that. He was so bruised and battered, and, in my opinion, in such fear of his father, because he's always like this. But this was horrific, because now the school is involved, and I think, he might have been afraid that, they might find out what was going on, because he wasn't in school. He was being abused somewhere else.
Okay. Okay. At some point later, Sean's a few years older, did you two work together? Mm-hmm. Okay. Where did you work together?
We worked in a seafood steak restaurant, Sea Shanty.
Okay. And where was that?
Sorry, just quickly pausing. LH says, to all the people saying hearsay, this is not a testimony for facts. It's a mitigation testimony. People talk about their experiences with defendants in mitigation testimony. Thank you so much, LH. Always insightful. Yes, and thanks for that reminder.
Restaurant located?
Fort Lauderdale, not far from our home.
Had Sean already been working there for a while?
Mm-hmm.
Okay.
A couple years before I went there.
Did he help you get that job?
Mm-hmm.
Okay. So when you started working together, what was his job title?
He was the master chef, the boss of the restaurant.
And how old was he?
At that time, bear with me for a moment. Maybe very late 20s, early 30s.
Okay. So what was he responsible for? What did he have to do?
He ran the restaurant. He was the restaurant manager, but he was also the head chef. He's a great cook. And being the type of restaurant that it was, being very nice, and, food critics coming in all the time and stuff, his boss, the owner of the restaurant, he was never with us, but Sean was the boss. So he would tell Sean, you have to make an appearance at least once in the evening, and he would have to put his white coat on and his chef's hat and go out and greet people, especially if we knew food critics were there. He would like to know anyway, just if there was something that maybe he didn't like or something and we could make it different. But yeah, he always used to go out and greet all of the customers that he spoke to, and he loved it. He loved his job. I mean, this was a good part of his life, and being responsible and on his own, and That was like a big thing to him.
Okay. Eventually, did he go to work at another restaurant? Like, did that
years
sea
later
shanty fail or something? And then
well, sea shanty actually tried to build other restaurants around, and I think Ohio might have been one of them, but Sean, they just crashed. They couldn't keep it going. So Minio's was a chicken place, and that was not far from Sea Shanty, same street, and just farther down the road. He went to work there as their head chef.
Okay. And eventually, did he, as a result of his job with Minio's, did he move to Tennessee at some point?
Mm-hmm. They wanted him to go up there. They wanted to open a restaurant. I think it was Knoxville.
Okay.
And they wanted him to open the restaurant.
At some point, did you and Sean kind of lose touch or grow apart?
When he moved to Tennessee.
Okay. Was that also when you and John Jr. were divorced as well? Was that perhaps a cause of that? Okay.
Yes.
What about when Frances moved to Tennessee? Do you know anything about that?
I only know that John, my ex-husband, and his new wife said they had no space in their home to care for her, and Danny couldn't, Colleen could not, and John said, "Let Mom come live with me. I'll take care of her."
Okay. Did he come pick her up in Florida?
I think so. I think it was him.
Okay. So when you were around Sean more frequently, I mean, I know it's been 30 years.
34, actually. Yeah.
Did he? How did he present himself? What was his?
Well, being out of danger and being on his own for years, I guess, helped him along. If you were to meet him and not know him, you would just think he was like any person, cordially mannered, kind to people, dressed well, nice vehicles, nice homes, beautiful wife. You're all around American person. You would never think that he went through the things that he went through or anything like that.
Did he have pets?
Oh yes, he loves his animals, dogs.
Okay. Was he abusing substances still, drinking or smoking or using drugs?
He would drink at night and smoke pot after work, but that was at his house.
Do you think he was drinking to excess? Did he have an issue with it?
At some point, yes, he started getting back into being drunk a lot.
All right. Well, we appreciate you being here, Roxanne, and you know some information about this case, why we're here today.
Yes.
Is that right? And you understand that we're in a sentencing hearing in this case.
Okay.
You understand the jury's already reached a verdict that he's guilty, that Sean is guilty of murder. You understand that?
Okay, yes.
Do you have an opinion on what kind of penalty he should receive?
Well, I believe in God so much, and I believe that I have to live by God's law. And I would probably just ask that no matter what, I don't believe in taking a life because it's not, for me to do. So it has to at least just spare his life. I mean, punishment for all according to their bad deeds certainly, should be administered. But, I mean, God, I can't. I just, to spare his life is probably what I would ask.
That's what it's, Judge.
Questions?
No.
Okay, thank you, ma'am. You step down. Appreciate the courtroom.
Okay.
Or leave, whichever you'd like to do.
Okay.
Thank you. So, ladies and gentlemen, we're going to go ahead and take our lunch break now. I'll go ahead and, if you'll go ahead and take our two alternates out first. Remember, don't discuss the case with each other. And then we'll start back here. I'd like to eat lunch a little bit quicker than we normally do, but if you don't get back, no problem. Let's say we start back at 1:30. Okay?
so we're going to be skipping over lunch, of course. That's why we start later, so just hang on tight. I just want to see if they say anything else. Okay. Seems like they might.
Ready? Everybody rise, please.
Jury, follow me.
Don't discuss the case among yourselves, please. Thank you.
Yes, copper horse over here, it's speedy. It doesn't even happen. Quick. At least the judge also said quick. They would have been back already. They're already probably back, obviously. I'm going to skip over that.
Thank you. Have a seat, please. So, for the defense, y'all anticipated additional witnesses, or was that it?
We rest.
Okay. And so, let's think about it.
Damn, the state's going quickly. The state rested in the sentencing phase, and now the defense has also rested. Wow. So it would mean closing arguments and jury deliberates. What? We're back on verdict watch soon.
About this a little bit. Do y'all want to go ahead and go through the Moman hearing now?
We can. That's fine. We discussed it. I discussed it this morning.
Okay.
Again.
Do you think he needs to sign the waiver again, or do you think just putting him on the stands enough?
I think. Can you?
Let's see what she says. Yes, ma'am. I want to do that. Okay. If you'll go,
I think we could just.
I think I've got. If you go in there and look on Judge Spicer's desk, you should see a document, a folder that says jury notebook. If you don't get that for me, please.
Judge, maybe we could just come back if the attorneys about 1:15 and do it before the jurors. And that way they have, because they have to close and they have to say they rest in front of jury.
Right. Yeah, I'll make this easy. Let me see if we got the form.
Okay.
I told him to go back there. It's sitting right here. I've got it. Do you want to go tell him? Never mind.
Yeah.
Thanks. Wait just a second. Let's see. This is my only one. Yeah, this is my last one. Would you just make a copy of this?
Just a few minutes, and then we're going to skip over lunch.
Thank you. So she's going to make a copy of the waiver and give it to you. You want to talk about sign it, then we'll put him up here and do that.
Can he, sorry, John, can he stay here like we did before?
Sure.
Okay, thank you.
I mean, is he going to... No spoilers if you know, but is he going to take the stand? Whoa.
While we're doing that, are y'all anticipating calling rebuttal proof? Or?
No.
Okay, so then when we come back, they'll rest, then we'll go straight into closing. Y'all go first, they go, and then y'all finish. Right? And then I give instructions.
Oh, my word.
Okay? Thank you, ma'am. So, counsel, if y'all can review that with Mr. Finnegan, get him to sign it for me. Whenever you get it ready, let me know, and I'll put him under oath.
Thank you.
Is that it? Anything else? Explaining to him what he has to sign. Okay. No sound. No sound. Okay. Okay, there he's signing it.
My colloquy at the table.
Sure, ready?
Yes, sir.
Okay, sir, if you raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Questions, counsel?
State your name, please.
Sean Finnegan.
Mr. Finnegan, am I your attorney in this matter?
Yes, you are.
And we are in the sentencing phase of a capital murder trial, is that right?
Yes, we are.
And we have been discussing, not only today, but in days prior, about whether or not you wish to testify at this stage of the case. Is that right?
Yes.
I want to go over a few things with you. I have an executed waiver, and it states, and I want to go over it again orally, that you understand you have a right not to testify, and if you chose not to testify, the jury may not draw any inference from your failure to testify. Do you understand that?
I do.
Second, you understand you have the right to testify, and if you wish to exercise that right, no one can prevent you from testifying. Do you understand that?
I do.
Third, you have consulted with counsel, that's myself and Mr. Rogers, in making this decision whether or not to testify. Is that right?
Yes.
And your counsel, both attorneys, have advised you of the advantages and disadvantages of testifying. Is that right?
Yes.
And finally, after considering your rights and asking any questions you might have regarding those rights, you have chosen to, A, waive your right to testify. Is that right?
Yes.
And you've initiated that box by checking, and you've also signed and printed your name. Is that right?
Yes.
And do you have any questions or other issues or confusion about this process?
No, I don't.
Is this what you want to do?
Yes, it is.
All right, may I approach this?
Sure. And so we'll mark that sentencing Exhibit 2. That will not go back with the jury.
Yes, sir.
So, Mr. Finnegan, you understand this is your decision, not your attorney's, correct?
Yes.
And they've explained the positives and the negatives of testifying.
Yes.
And you're agreeing freely and voluntarily that you're waiving your right to testify.
Yes, I am.
Okay? I'll be looking. Thanks, sir. So we'll stand recess until 1:30.
Yes, sir.
Thank you.
Okay, now we get to skip over, teleport, and we'll always be oh wow, we're gonna be almost all caught up. What? Eh? Are they back yet? Okay, hold on. Wait. They said 1:30. It's 1:56. Okay, wait. Just checking we don't miss anything. All right, well, now I've got to refresh the feed, so stand by.
Because of who you are.
Wait. Okay. Somewhere there. What is going on here? Wait, we're going to just go back a little bit. We should only be a few 20 minutes behind or so. Yeah, there we go. Already. Here we go.
If y'all bring in our jury, please.
It's a verdict form in here.
Yes, Corporal's lunch break is over. We're done. Okay, so it's going to be closing arguments now in the sentencing phase. So state will go, defense will go. I don't know if there's going to be a rebuttal, but jury instructions and verdict watch? What? We're going to be on verdict watch round 2.
We're going to reflect all our jurors are back. Any further proof from the defense?
The defense rests, Judge.
Thank you. Any rebuttal proof from the state?
No, Your Honor.
Thank you. So now, ladies and gentlemen, the part of the trial will be, we'll hear closing arguments in regard to sentencing. The state will go first, then the defense, then the state finishes. After that, then I'll just give you a few instructions, and then y'all get your deliberation. All right? Okay. Closing arguments.
In opening, I talked about mercy and not giving this defendant the mercy that he didn't show to Jennifer Paxton. And when you examine factually what happened in this case, was there any mercy that he showed upon Jennifer? In the 4 days, did they show any mercy upon her? And the only thing factually you could probably muster is the fact that they applied her with morphine, arguably Miss Finnegan's morphine, that they gave her something to dull her pain. And so the only potential for mercy was maybe, just maybe, that she didn't experience the amount of pain that all those injuries looked like they would have inflicted on a normal person of normal sensibilities, right? But there's also, when you really think that process through and what he's like and what she's like, what they did to her, maybe that morphine was to dull her sensibility so she couldn't cry out, so she couldn't escape, so she would be more compliant. And so you look at that potential mercy, and there's a double-edged sword there. Was there really any ever mercy that he showed upon Jennifer Paxton? And the answer will probably be no. And when you examine that and think about the circumstances under which this crime occurred, and we talked about the 4 things that the state has elected and how you're going to now put those on a scale with the aggravators on one side and the mitigators on the other. And if the aggravators outweigh those mitigators beyond a reasonable doubt, your sentence shall be death. There's no way around it. And to talk about those aggravators that the state has put forward, the first one that we talked a little bit about opening, and I want to point your attention to this. This doesn't say that Sean Finnegan was especially heinous, atrocious, cruel, or that he tortured or seriously physically abused. It doesn't say Rebecca Dishman was especially heinous, atrocious, or cruel, or that she tortured or seriously physically abused. It says the murder. The murder itself. Their conduct, what they did. If what they did was especially heinous, atrocious, or cruel, in that it involved torture. And so the judge is going to instruct you on what the word torture means, and it involves physical pain, right? You saw that, you heard that from Dr. Malusinik, you understand all the wounds, you have ad nauseum, I'm sure, gone through the photographs and everything that you need to go through to reach that conclusion. You know that. She was in physical pain. That may have been mitigated by some of the morphine that they were pumping her with, but nonetheless, physical pain. The slit throat, the ligature applied 5 different times, the blunt force trauma that Dr. Malusinik went over in the black notations on the body, on the mannequin, and the sharp force trauma on all the red markers on her body. She endured every single one of those cuts and strikes over a period you now know of 4 days. So you think about the physical pain that she went through, but torture also involves mental pain, right? You think about what she endured, what Jennifer Paxton endured over those 4 days, how she was chained by the neck with a padlock around her neck in a bedroom in a dank apartment with no medical attention and wondering every second what's going to become of me. With people hovering over, having sex and climaxing, him forcing her, raping her. What they did to her over those 4 days was mentally torture and physically torture. And so this aggravator that we're talking about, the court is going to show you take and whether or not the state proved beyond a reasonable doubt that aggravator, that woman over 4 days was put through pure hell, which equals torture. And if you find that, you take that aggravator and you assign a weight to it. And I would tell you, ladies and gentlemen of the jury, that aggravator alone is a triaxle dump truck full of gravel, 20 tons. Back it into this courtroom and dump it on the scales. You won't even find them. And I'd ask you to find that, because that's what Jennifer endured. 4 days in that apartment, defecating and urinating in a bucket. That's torture. And we set that apart by these aggravators. We talked a little bit about different types of crimes. We talked about a bank robbery, right? And I talked a little bit about a drive-by shooting. And I said to you that drive-by shootings happen. An altercation occurs somewhere else. People argue. They over gambling or drugs or whatever it is, and then somebody comes back and retaliates at a later date or later time, shoots somebody in their front yard, and a drive-by shooting occurs. That's a first-degree murder, right? And so the reason that we have aggravators and the reason you're contemplating the death penalty in this case is because not all murders are the same. And again, I told you in the beginning, drive-by shootings are a scourge to our community. They cause wreckage and havoc among people and lost lives and whatnot. But it's different here. This homicide is different than a drive-by homicide because you don't have aggravators in that kind of case. You think about somebody who's shot in their driveway. Yes, it's horrible, it's terrible, but there wasn't no torture. There wasn't going to be any mutilation of anybody's body in a drive-by. There isn't going to be a substantial role that a person played in a felony to get them to the homicide like we're going to talk about in a second. And there wasn't a homicide occurred to avoid an arrest. Those are the 4 factors that we're talking about in this case. We're talking torture, substantial role, avoiding arrest, and mutilation. None of those occur in a drive-by type situation or even in a bank robbery situation that we talked about when the state has to deal with co-defendants, when multiple people commit felonious acts. So that's what distinguishes this crime from others, and that's why we have to prove the aggravators in this crime and why he deserves death. Because of these aggravators. And this one is the dump truck, full of weight. And I'd asked you to sign it, that he tortured her, that they tortured her. The next factor the state was relying on is the murder. Not him, but the murder itself was committed for the purpose of avoiding or interfering with a lawful arrest or prosecution of the defendant or another. And you think about over the 4 days how things developed as they were involved in the torture that they did upon her, all the physical and mental pain. You think about how that progressed. It went from the point where, she is really seriously injured. At this point, they can't let her go. At this point, they're going to have to keep plying her with pain medication, which is, that's their pain medication. At some point, you have to believe that in their minds, they realized they could not let her go. And they could not let her go because of the consequences of what they had already done. And I want to remind you of what the defendant said when he was questioned by Mike Ewer about why he chained her up. Well, why'd you bring her up in the bedroom and chain her up? What was that all about? And he said that he couldn't let her go after what had happened. Couldn't let her go after what... This is over just the baseball bat incident. When he claims that she was struck by Rebecca Dishman with a baseball bat, he couldn't let her go then after what had happened. And so the logical conclusion, the next step is after the next 4 days where they're just abusing and raping and defiling her person and mentally abusing her, certainly they couldn't let her go. Why? Because they would face consequences for that. Arrest, prosecution. Exactly what this aggravator is about. And as far as the application of it, the weight that you put on it, that's up for you. That's the province of the jury. That's what you're here for. That's what you do. And so you'll take that weight and you'll add it onto the pile of gravel that's already here in the courtroom. For factor number 2, because the state only needs to prove 1. The judge will instruct you on the law on that. But factor number 2, that you'll pile that onto that load of gravel. And you think about other reasons why, the other things, actions that they did, think factually what to avoid the arrest. You remember he got rid of the murder weapon, right? He got rid of her belongings, her clothing, whatever she brought there with her, burned. Backpack, I think, maybe, of her belongings. But all those are mindful of the fact that they were avoiding the consequences of their confinement of her and their torture of her. And so that factor, that second factor, will add them on. The third factor the state has elected for you to consider is that the murder was committed while the defendant had a substantial role in the rape or kidnapping. Okay? Different from what you read in your original instructions in that you've already found him responsible. Because you found him guilty for first-degree felony murder, that he is responsible, that he is part and parcel of the original felonies of kidnapping and rape, and the killing occurred during the commission of that. So you've already found that. This factor is if he had a substantial role in that. And you think about the role he took in the kidnapping and whether or not it was substantial. He did it. He caused he started the whole ball rolling. Right? He found her. He isolated her. He knew her from the Pine House. He's the one who selected her for the purpose of bringing her back to Oak Ridge. And so it's his conduct that we're even here, to even bring her to Oak Ridge. He admits putting the chain around her neck. He raped her. And we can't forget, obviously, that he went and rented the freezer. He continued to keep her from her family for 8 months, moving the freezer upstairs and denying his responsibility when confronted. All of that goes to whether or not he had a substantial role in the underlying felonies, which are the rape and the kidnapping. And I would argue to you that you could put significant weight on that he was the role. That Rebecca Dishman was sitting at home waiting on the prey, so to speak, to be brought to her. And he did. And he had a substantial role. And so that third factor, you'll take that aggravating factor and you find it upon a reasonable doubt, and you'll put a weight on that, and you'll put it up on the pile with the dump truck and the second aggravator, and you'll throw more weight on the pile. And then we get to the fourth factor that the state is relying upon. And like I said, in a drive-by shooting, these things don't occur. That's why this is a death penalty case. That the defendant knowingly mutilated the body of the victim after death. And folks, that you have seen the evidence of that. You heard Dr. Malusinic talk about the types of cuts that they look like they were intentionally done. You know that he removed that body from, and let me back up a little bit, and is putting a body in a freezer in a master closet, some sort of mutilation, knowing that it's going to change its composition. In and of itself, much less the cuts and the removal of parts in the nose and her areola and the parts that had to be removed from the side of the freezer when they were freezer burnt. That's mutilation. And so you'll take that mutilation that you know has been proven, obviously as a jury, take it as an aggravator, and throw it on the pile. And then you'll look at the mitigators. He had a bad childhood. And you're going to put weight on that. And you're going to put it on the scale against the mountain of gravel that dump trucks had to bring in here. And weigh the two. And if the state has proven based on those aggravators that they outweigh the mitigators, then you shall impose death. And that is a profound thing for me to ask you to do. I know that. And I don't take it lightly up here saying that to you. A difficult thing to ask. But it's following the law. And a verdict in this case of death will be showing him mercy. Be showing him mercy. The only thing he did mercy-wise for Jennifer was to put some drugs in her and torture her for 4 days. The state would put drugs in him, and he'd nod off. Far more merciful than what he did to Jennifer Paxton. Sentenced him to death.
Thank you. Defense?
Yes, Your Honor. Bear with me a minute. We'll move this podium. Yes, sir. Throw my paper on the floor at the same time. Well, the state is once again arguing a lot of they talk. They did this, they did that, which is fair. But I don't know that it corresponds with the verdict that you returned yesterday on many of these charges. We have acknowledged the tragedy in this case, and it is a tragedy. It's horrible what happened to Jennifer Paxton. It sounds like from hearing all the evidence in this case that it was a lot of broken people that were harming themselves and harming each other. And as I said before, we're not here to assign any kind of blame or shame to Ms. Paxton. But it seems like she had her own struggles and demons in life that she was dealing with, but that's no excuse for what happened. I mean, it's awful. And I'm not here to minimize what was done to her in that apartment. But at the same time, in reaching your verdict today, you cannot just lump them in together. You have to separate them and make a particularized finding to elevate and necessitate and justify a sentence of death in this case. And you'll see in these jury instructions the court's going to give you what additional things was Sean Finnegan doing beyond that necessary to have committed these crimes to justify a sentence of death. Again, I would just point out, as I did in opening, he's not ever going to get out of jail again. He's going to be in chains and locked up for the rest of his life. So is Ms. Dishman. So as we go through this, we're going to talk a little bit about the legal principles. We're going to go back through some of his social history. I know we just heard it a moment ago. But I want you to keep in mind, and the court will instruct you on the proportionality between the two of them, Dishman and Finnegan, in reaching your verdict. What is fair? Because it seems to me, in trying to read the tea leaves and analyze and draw conclusions from your verdict yesterday, that your decision was that Mr. Finnegan was less culpable in the sense of premeditation in this case. And we've heard in this trial from the only person that's been convicted of premeditated first-degree murder. She sat right there. And it seems that some of her testimony, most all your decision to make as jurors, was incredible. So once again, we acknowledge your verdict in this case. Sean Finnegan, as it stands right now, based on the felony murder conviction, will be held accountable for what has occurred. He will spend the rest of his natural born life in the custody of the Tennessee Department of Corrections. Again, your decision is whether or not he should be sentenced to death. And from a mechanical application, we do have to talk about the legal principles at issue here, which are the application of the state's aggravating circumstances and the defendant's mitigating circumstances. The judge will instruct you that you have to find each of the state's alleged, in their allegations, each of the state's alleged aggravating circumstances beyond a reasonable doubt, and you have to find that it outweighs all of the mitigation presented beyond reasonable doubt. Again, aggravating circumstances are a reason to kill. Mitigating circumstances are a reason to live. So in considering the state's aggravating circumstances, you all, as a court will instruct you, have to reach a unanimous decision. You all have to agree that they apply. For mitigation, there's no such burden on us. You all do not have to unanimously find that the mitigating circumstances should apply in this case and how much weight to give them. There are 12 of you sitting up there. Okay, you have to deliberate. The court's instructed you. You've already done that. You have to continue to deliberate and work as a group. But you're also, each of you, a jury unto yourself, individually. And, the state talked about common sense and the guilt and innocence phase. But Each of you comes to this jury and serves on this jury and was selected to be on this jury because of who you are, because of your walk in life, your individual moral compass, the things that you've experienced, the trauma, the good things, the victories, the defeats. There's a reason why you're here and why you were selected to be here, and you don't leave that at the door. And as you sift through the evidence in this hearing and the evidence from trial, which you're supposed to consider all of this in reaching your decision, as you sift through it, each of you can decide on your own, for whatever reason, to apply weight to a given mitigating circumstance. And that doesn't have to necessarily be for, as the state paraphrased, bad childhood. Okay? Sure, we're going to talk about this some more. I'm not going to go through it all. But it could be for other fundamental principles that we all live with, such as mercy or sympathy. And as I stated, it can be anything. And my point is, if you reach a decision in this case, you don't have to violate that decision if someone else disagrees with you. The court will encourage you to deliberate and work amongst yourselves, but I'm here to tell you, you're here for a reason. We wanted people that came from all walks of life and that have strong personalities, and we want you to continue to be strong. We want you to continue to be an individual and speak your mind if you want to, but you don't have to. The state has alleged several aggravating circumstances in this case. Again, a lot of the use of the word they. I would encourage you to try to split apart Mr. Finnegan from Ms. Dishman as you go through these. As to the so-called torture or serious physical abuse, I spent a lot of time working late last night trying to understand this in relation to your verdict. And I don't think it's very easy, but you came back with a verdict of attempted aggravated rape as to count 4 and not guilty as to count 5, but guilty as charged as to count 6. So my takeaway from that is that you all struggled with a very violent and horrible situation. I'm not minimizing that, but it's not crystal clear and evident what exactly was happening in that room. And, oh, by the way, the state keeps talking about 4 days this and 4 days that. To me, that sounds like it came from Mr. Finnegan's statement. So Ms. Dishman had a different timeline, if we're going to go back and talk about Dishman's several recollections about timelines. But I think the point that I'm trying to make is that you need to try to split apart Mr. Finnegan from Ms. Dishman. And as it relates to torture, you need to think that's not just that torture was inflicted. It is what was inflicted beyond that necessary to produce death. Serious physical abuse, what was inflicted beyond that necessary to produce death? I think the blunt force trauma that Ms. Paxton suffered on her shoulder and arms from the bat, that incident occurred early on in that process. That wasn't going to produce death. I think the medical examiner talked about that. The cause of death was strangulation, and you saw the ligature on her neck. What beyond that did Sean Finnegan do to either torture or cause serious physical abuse? As it relates to kidnapping, again, I'm not here to minimize what Sean's actions were, but the physical act of chaining her, that was to accomplish the kidnapping. That wasn't above and beyond what was necessary, and it certainly didn't produce death in that circumstance. The avoiding or interfering with under Section 6 of the aggravators, that's where you have to ask yourselves, what was the motivation? What was the motive? Why did Sean do that? Well, you all returned a lesser included offense on premeditated first-degree murder of criminally negligent homicide. You acquitted him of conspiracy to commit first-degree murder. Ms. Dishman has been convicted of both of those offenses voluntarily. She pled guilty to them. So to me, that signifies that you believe that Ms. Dishman had some more responsibility for causing the murder. Felony murder is relatively straightforward, and again, we've accepted that verdict. But from my reading of your verdict as it relates to Sean Finnegan's culpability for committing first-degree murder by premeditation, I think the evidence shows that it was Rebecca Dishman who was driving that bus. That, once again, this horrible chain of events happened in the house, and Mr. Finnegan went to work. And he came back, and Ms. Paxton had died. That doesn't sound like there's proof that Mr. Finnegan intentionally killed her to avoid arrest or prosecution. On the felony murder aggravator, that's what he's convicted of, as charged. That conviction alone cannot serve as grounds to find that aggravating circumstance. You have to find something more in the evidence. The state wants to talk about he was the role. And with all due respect, they're going back and they're relitigating this prey theory, which I think was not in evidence and is not reflected in your verdict. As to the mutilation aggravator, I would just say that Sean Finnegan has been convicted of both tampering with evidence and abuse of a corpse. You all convicted him of that. He's going to be held responsible for that and punished for that. The only thing I would say is even the medical examiner could not tell us when the body was mutilated in that 7-month period and by whom. Again, you must make a particularized finding as to Sean Finnegan so that it's elevated because the punishment is so severe. Now, we have filed and we have presented mitigation in this case. I'm not going to rehash all of that testimony. I think it speaks for itself. We appreciated Roxanne Mundy being here, but I think it's important for you all to know about Mr. Finnegan, where he's from, how he grew up, and the trauma that he received, and how it affected him as he became a young adult and an adult. From a legal standpoint, there's a few takeaways I want to leave with you. Once again, you all get to decide the weight to give both the aggravating circumstances and the mitigating. You don't have to follow this mechanical operation of a set of scales, dump trucks, pebbles, rocks, boulders. I think it's a good physical analogy, but it doesn't encompass the gravity of the decision that you've got to make in this case. We're not pulling a lever here. You can think about things like pity and mercy and sentiment and sympathy. And each of you individually can be the sole judge of whether one of these factors exists and how much weight to get it. And again, we don't have a burden of proof on our mitigation. The state has to disprove our mitigation beyond reasonable doubt, and that's all of it. So our mitigation, as you'll see in the instructions, deals with his background, much of it his social history, his employment history. He's worked for about 40 years. In our estimation, allowing him to go to prison, to serve out the rest of his years. He potentially could work in prison. You've seen his demeanor throughout this case. Pretty low-key guy, stay out of the way, not cause any problems. That's Sean Finnegan at this stage in his life. Is it sad? Is it pitiful, pathetic? And he's been sitting out the Anderson County Jail for 4 years, waiting for trial in this case. His life is effectively over, but we think that he can go on and still function and be helpful. He has job skills, and you heard from Ms. Mundy and Ms. Miller that he's a reliable guy, he's dependable, and he's a hard worker. And we think that counts for something. Now, the other mitigation, his social history, his life, it's pretty brutal stuff. It doesn't sound like he or many of the other kids really got a decent start at life. Dropped out of school in the 8th grade, low education, functioning, but low education, and suffered sex abuse, physical abuse, verbal abuse, not a pleasant childhood, but I think the takeaway is that he endured. He survived. He didn't have a lot of network or services available to him, but he survived and did the best he could. We're talking about the late 1970s into the 1980s. It's not the same as it is today. And eventually he moved to Tennessee, and he brought Frances Finnegan with him because it sounds like there wasn't room for her at the other siblings' houses, and he took care of her, and they lived together. I know it's kind of a bizarre side issue to this case that Frances Finnegan was living in that apartment the whole time, but she did pass away. But the takeaway I think that's important is that despite all this brutality and carnage and disrespect of another human being, that somewhere, somehow, Sean Finnegan does have love in his heart, and he took care of his mom until he came to jail, and then she passed away after that. So beyond the mitigating factors, which I believe we have proven beyond a reasonable doubt, in which I think are enough to outweigh the state's aggravating circumstances in this case, the last major issue I want you to consider, and then I'll sit down, is proportionality. Is it fair? Based on my reading of your verdict, as it relates to premeditated first-degree murder, you came back with a very low lesser-included offense, and you acquitted him of the conspiracy count related to that. Rebecca Dishman is guilty of those counts, and she's going to prison for the rest of her life. And in exchange for her testimony, her death notice was withdrawn by the state of Tennessee. The way I see it, is it fair for Sean Finnegan to receive a sentence that is greater than Rebecca Dishman's? That he should be put to death? When you all have sat here for a week and evaluated this case under the law and found that he is less culpable than her for the premeditation angle in this case, he should be put to death? I mean, it's horrible. We're not here to minimize what has happened, but I get the feeling that some of you, maybe all of you, tend to agree that maybe Ms. Dishman had more to do with this than the state has been arguing and that the state tried to present in this case. So we do not think it would be fair. It would be disproportionate for Sean Finnegan to be put to death when Rebecca Dishman was the one that strangled Ms. Paxton in the floor of that apartment. People with limited intelligence are probably susceptible to domination and manipulation. I think that's probably fair, maybe for both Ms. Dishman and Mr. Finnegan. People that have prior sex abuse are predisposed to sex activity that most of you would find depraved. I think that encompasses the negative parts of Sean Finnegan's early life and perhaps explains, in part, why we are all sitting here talking to each other today. But at the end of the day, as I told you in my opening statement, the law recognizes a life sentence. Okay? That is a legal sentence. It is a lawful sentence. And it is a proportional and fair sentence in this case. And so we ask that when you go back there, this is an awful decision that you have to make. It is an awesome decision that you have to make. I think that when we think about voting anymore, I think it's easy to be cynical about how much weight our votes count in the political process. Well, this will be the most consequential vote that each of you is ever going to cast. And I don't think there's anything you have to worry about Sean Finnegan ever getting out of jail again. We think it's appropriate to allow him to die naturally in prison. So we ask you to vote for life in this case. Thank you.
Thank you, counsel.
I wonder, I can see people are very upset in the chat, but don't you think, I wonder if you will, I think you'll make some jurors think about it, especially because of what their verdict was, right? That lesser charge under the first degree murder one, right? So I think that they might bring that up again, being like, maybe some of you think that Rebecca Dishman had more to do with this than him. Then he might as well say, so how can you sentence him to death? Oh, I wonder if that will like play on their minds, you know what I mean? So, but I love reading your comments to see what you think of this. Whoa, let's see now. Now it should be jury instructions and then verdict watch, if I'm not mistaken. Let's hear it.
And for the state?
Ah, true. Rebuttal. Ooh, it's rebuttal time. Ooh, and this attorney is very, very good. I'll put her name on the screen as well.
We can talk about what's fair, but unfortunately in this situation, fairness has very little that we can weigh on here, because what is fair is if Jennifer Paxton were still here. And so what justice is in this case is the maximum penalty for Mr. Finnegan for what he and Ms. Dishman did to Jennifer Paxton. Premeditation is sort of a red herring here. We're not asking you to impose the death penalty on count one, and that was the premeditation count. These aggravating factors that the state has set before you are applicable, to counts 2 and 3 only. And so those are the felony murder counts. And so whose idea it was, who planned it, isn't something for consideration on this, because you as the jury have weighed that evidence and decided that count 1 was off the table, frankly, for this sentencing portion of this case. And so the state submits to you that we have proven beyond a reasonable doubt through the course of this trial each and every one of those aggravating circumstances. And we submit to you that any one of those aggravating circumstances far outweigh the mitigation proof that's been put in front of you today. And we do not in any way believe that this is an easy decision. When you were selected for the jury, each of you did say you would meaningfully consider, because that is the baseline, to look at the evidence and weigh it very carefully. It is a great and heavy responsibility to weigh these factors. But the state believes that when you do and you consider the proof, that each one individually outweighs the mitigation, and together those factors far, far outweigh the mitigation, and that the just sentence here for Mr. Finnegan is the maximum allowable by the law. There's question about what's fair or what the difference is between Ms. Dishman and Mr. Finnegan. The reason that we know about this is because Ms. Dishman disclosed. The reason that Ms. Paxton's family was able to end their search and get the answers, regardless of how horrible those answers were, was because Ms. Finnegan disclosed, implicating herself in that and accepting the responsibility for it. To contrast it, Mr. Finnegan continued to deny until presented with irrefutable proof, and then made some concessions. By his own statement, he was actively engaged in the kidnapping, in the cover-up, in all of this, far beyond, and you've heard the proof, but beyond what was necessary for the crime. So when we talk about, well, there were these bruises or these hits or these cuts, and those didn't cause death, that's what we're talking about. None of those were necessary to cause death. And one choking incident could have caused death, but we have at least 5 ligature marks. And as General Allen said, it does not matter which individual committed each of those ligature marks, each of those strangling. They are in it together, and they convicted. He was convicted of the conspiracy. He was convicted of the felony murder by kidnapping and the felony murder by rape. He is part and parcel of all of this. He had the opportunity every single day to leave and intervene. He was going to work, acting casual, joking around, apparently. And yet, his cover-up continued of it. You've heard the proof. Again, this has been an arduous task and lengthy, and so I will not belabor every bit of evidence that you have already heard, but would reiterate that for the actions that were done to Ms. Paxton, for the torture that she endured, for the mutilation to her body, which we know was done by Mr. Finnegan. He had to cut her out of the freezer. There was freezer burn on that. She was stuck to the freezer, according to the medical examiner. We know he was engaged in that, and freezing does change the body. Both of these things that you know irrefutably that he did, that he told you he did, support the mutilation. And the mitigating factors do not outweigh the aggravators here. Justice for Jennifer Paxton is the maximum sentence in this case. And we ask you to meaningfully consider this proof and the aggravators and the mitigators, and we will ask you to impose the maximum sentence. Thank you.
Thank you. Jeff, if you could hand out these jury instructions.
Very nice. Okay, jury instructions.
Jurors, I think there's 14 there, I hope. All right, I think each one of our jurors have a copy of the jury instructions. Let me review those documents with you. Members of the jury, you've now found the defendant guilty beyond a reasonable doubt of murder in the first degree as charged in indictment number C1C00518. It is now your duty to determine within the limits prescribed by law the penalty which should be imposed as punishment for this offense. Tennessee law provides that a person convicted of murder in the first degree should be punished by death, by imprisonment for life without the possibility of parole, or by imprisonment for life. A defendant who receives a sentence for imprisonment for life shall not be eligible for release until that defendant has served no less than 51 full calendar years of such sentence. A defendant who receives a sentence of imprisonment for life without parole shall never be eligible for release. Each of you must decide the case for yourself, but you should only do so after discussing the evidence and instructions with your other jurors. In arriving at this determination, you are authorized to weigh and consider any of the statutory aggravating circumstances proved beyond a reasonable doubt, and any mitigating circumstances which may have been raised by the evidence throughout the entire course of the trial, including the guilt-finding phase or sentencing phase or both. Mitigating circumstances do not have to be proven beyond a reasonable doubt, but rather they are considered if raised by the evidence. The jury is the sole judge of the facts, and the law that applies to the facts in the case. In arriving at your verdict, you will consider the law in connection with the facts, but the court is the proper source from which you are to get the law. In other words, you are the judges of the law as well as the facts under the direction of the court. The burden of proof is upon the state to prove any statutory aggravating circumstance or circumstances by reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof in the case and inability after such investigation to let the mind rest easily as to the certainty of your verdict. Absolute certainty is not demanded by the law, but moral certainty is required. And this certainty is required as to every element of proof necessary to constitute the verdict. The law makes you, the jury, the sole and exclusive judge of the credibility of the witnesses and the weight to be given to the evidence. The prosecution has introduced what is known as victim impact evidence. This evidence has been introduced to you to show the financial, emotional, psychological, or physical effect of the victim's death on the members of the victim's immediate family. You may consider this evidence in determining an appropriate punishment. However, your consideration must be limited to a rational inquiry into the culpability of the defendant, not an emotional response to the evidence. Victim impact evidence is not the same as an aggravating circumstance. Proof of an adverse impact on the victim's family is not proof of an aggravating circumstance. Introduction of this victim impact evidence in no way relieves the state of its burden to prove beyond a reasonable doubt at least one aggravating circumstances which has been alleged. You may consider this victim impact evidence in determining the appropriateness of the death penalty only if you first find that the existence of one or more aggravating circumstances has been proven beyond a reasonable doubt of the evidence independent from the victim impact evidence, and find that the aggravating circumstances found outweigh the finding of one or more mitigating circumstances beyond a reasonable doubt. Statutory aggravating circumstances. Tennessee law provides no sentence of death or sentence of imprisonment for life without possibility of parole shall be imposed by a jury but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more of the statutory aggravating circumstances, which should be limited to the following. 1. The murder was especially heinous, atrocious, or cruel that involved torture or serious physical abuse beyond that necessary to produce death. 2. The murder was committed for the purpose of avoiding, interfering with, or preventing a lawful arrest or prosecution of the defendant or another. 3. The murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing or attempting to commit, or was fleeing after having a substantial role in committing or attempting to commit any rape and or kidnapping. Knowingly means that a person acts knowingly with respect to the conduct or circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct which the person's conscious objective or desire to engage in the conduct or cause the result. 4. The defendant knowingly mutilated the body of the victim after death. Knowingly has been defined in subsection 3. Refer to that definition herein. You're instructed that the word heinous means grossly wicked or reprehensible, abominable, odious, or vile. Atrocious means extremely evil, cruel, monstrous, exceptionally bad, abominable. Cruel means disposed to inflict pain or suffering, causing suffering or painful. Torture means the infliction of severe physical or mental pain upon the victim while he or she remains alive and conscious. Members of the jury, the court has read to you the aggravating circumstances which the law requires you to consider if you find proof beyond a reasonable doubt. In order to consider any aggravating circumstance or circumstances in your sentencing determination, all 12 jurors must unanimously agree such circumstance or circumstances have been proven beyond a reasonable doubt. You shall not consider any other fact or circumstances as an aggravating circumstance in deciding whether the death penalty or imprisonment in life without possibility of parole would be an appropriate punishment in this case. If you unanimously determine one or more aggravating circumstances have been proven beyond a reasonable doubt, it is then each juror's individual determination as to how much weight any such aggravating circumstance should be given in weighing the aggravating circumstance with any mitigating circumstance. Mitigating circumstances. Tennessee law provides that in arriving at any punishment, the jury shall consider, as previously indicated, by any mitigating circumstances raised by the evidence which shall include but are not limited to the following. A. Any residual doubt as to defendant Finnegan's guilt, which may consist of any proof or evidence which indicated defendant Finnegan may not have committed the offense, notwithstanding the jury's verdict. 2. Any evidence defendant Finnegan was raised in an unstable and volatile home environment, including evidence he lived with his family in a vehicle as a young child. 3. Any evidence defendant Finnegan's father was an alcoholic who exposed defendant Finnegan to seeing his father repeatedly, physically and emotionally abuse his mother throughout his childhood and adolescence. 4. Any evidence defendant defendant Finnegan was raped, sodomized, prostituted, and sexually exploited as a child while in the care of his extended family member. 5. Any evidence defendant Finnegan experienced emotional instability. 6. Any evidence defendant attempted suicide at the age of 16. 7. Any evidence defendant Finnegan attempted to self-medicate and treat his depression with the use of alcohol and drugs. 8. Any evidence defendant Finnegan only had an 8th grade education. 9. Any evidence defendant Finnegan has the work skills enabling him to be productive in state custody. 10. Any evidence of the sentence received by the codefendant Rebecca Dishman, who testified in this manner. And 11. Any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing, that is, you shall consider any aspect of the defendant's character or record or any aspect of the circumstances of his offense favorable to the defendant which is supported by the evidence. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance, or that you agree on the same mitigating circumstance. If you individually determine one or more mitigating circumstances have been raised by the evidence at either the guilt or innocent phase or the sentencing phase of these proceedings, it is then each juror's individual determination as to how much weight any such mitigating circumstances should be given in weighing the aggravating circumstances with any mitigating circumstances. The defendant has not taken the stand to testify as a witness during the sentencing hearing, but you shall place no significance on this fact. The burden is on the state to prove 1, any aggravating circumstance or circumstances beyond a reasonable doubt, and 2, that the said circumstances or circumstances have been proven by the state to outweigh the mitigating circumstances or circumstances beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such a fact. If you do not unanimously determine that the statutory aggravating circumstances have been proved by the state beyond a reasonable doubt, the sentence shall be life imprisonment. You will write your verdict form in enclosed form. Verdict form hereto and made a part of this charge. The verdict shall be as follows. We, the jury, unanimously find that the punishment shall be life imprisonment. If you unanimously determine that a statutory aggravating circumstance or circumstances have been proven by the state beyond a reasonable doubt, but that such statutory aggravating rape or circumstances have not been proven by the state to outweigh any mitigating offense beyond a reasonable doubt, you shall, in your considered discretion, sentence the defendant either to life or to imprisonment for life without possibility of parole or imprisonment for life. In choosing between the sentence of imprisonment for life without possibility of parole and imprisonment for life, you shall weigh and consider the statutory aggravating circumstances or circumstances proven by the state beyond a reasonable doubt and any mitigating circumstances or circumstances. In your verdict, you shall reduce to writing the statutory aggravating circumstance or circumstances so found, and you shall return your verdict upon the closed form. Attached hereto and made a part of this charge. The verdict should be as follows. We, the jury, unanimously find that the state has proven the following listed statutory aggravating circumstances or circumstances beyond a reasonable doubt. We, the jury, unanimously find that such statutory aggravating circumstances or circumstances do not outweigh any mitigating circumstance or the circumstances beyond a reasonable doubt. Therefore, you shall then indicate on the clear verdict form either we, the jury, unanimously agree that the defendant should be sentenced to imprisonment for life without possibility of parole, or 2, we, the jury, unanimously agree the defendant shall be sentenced for imprisonment for life. The verdict must be unanimous and signed by each juror. In regard to death, the verdict for death. If you unanimously determine that at least one statutory aggravating circumstance or several statutory aggravating circumstances have been proven by the state beyond a reasonable doubt, and said circumstance or circumstances have been proven by the state to outweigh any mitigating circumstance or circumstances beyond a reasonable doubt, the sentence shall be death. The jury shall reduce to writing the statutory aggravating circumstances or statutory aggravating circumstances so found, and signify the state has proven beyond a reasonable doubt that the statutory aggravating circumstances or circumstance outweigh mitigating circumstances. You will write your findings and verdict form in enclosed forms attached hereto and made a part of this charge. Your verdict shall be as follows. We, the jury, unanimously find the following listed statutory aggravating circumstances or circumstances beyond a reasonable doubt. You'll then write out which statutory aggravating circumstance or circumstances you relied on. Next, we, the jury, unanimously find the state has proved beyond a reasonable doubt that the statutory aggravating circumstance or circumstances so listed outweigh any mitigating circumstance, and therefore we, the jury, unanimously find that the punishment shall be death. The verdict must be unanimous and signed by each juror. It's important that you take the case and consider all the evidence fairly and impartially and complete one of the 3 verdict forms and report your verdict to the court. And here are the 3 verdict forms here that I'll give to you to go back and consider. We had 1 exhibit, so I'm going to give you that 1 exhibit as well to take back. Our plan for the rest of the evening is I'm going to let y'all work till about 5 or 5:30. Bring your 4-person in and ask if y'all want to keep working or you want to call it a day and come back tomorrow. And that's really solely up to y'all. Whatever your decision will be is fine with us. So it's just kind of your call on that. When you do reach a verdict, if you'll just knock on the door and tell one of the deputies that you have in fact reached a verdict, then we'll bring all of us in together and then we'll determine and then we'll announce the verdict from there. Everybody understand that? Anybody got any questions? Okay, let me give that to you. Give them the verdict form and the 1 exhibit. All right, everybody rise, please.
Judge.
I need the alternates to stay here.
You said you wanted to tell them to remind them that if they have any kind of a question.
Thanks, I forgot that. If y'all have any kind of question, like we did last time, be sure you write the question out and then sign it. The 4-person to sign, put the time, because I have to keep up like 1, 2, 3, 4, how many questions there are. So be sure you do that. All right? Okay? See y'all in a few minutes. See you when you deliberate. Thank you. Go ahead and take those 2 and then come back.
See you in a few minutes. Go in and come out, we're done.
Back and we'll take care of our alternates. Take them. Yep, jury first. Thank you. Have a seat. I can have a seat too. So my 2 alternates. The laws in Tennessee, once they start deliberating on a punishment, then that's it. So if they get sick or sometime under, I got to do it over again. So hopefully they won't do that. I want to tell you, I appreciate y'all's service in this. I know it's been difficult, but I do appreciate it. And I think I can say it on behalf of all the parties here, as well as the family members and the other people who have been involved in this case. When you leave today, if you'll give your jury books to my court officer here, we'll put those notes will be destroyed. Nobody will ever see those. Someone will take you back to the hotel and y'all can pack up and go back home. There is a possibility that you might be contacted by the press. If you are, what you'll do is you'll get an email from the clerk that says they've been contacted and one of the jurors want to speak to the press. So when you're called, you don't have to. You can just say no. And that's fine. But if you want to, then he'll give you the name to call or something like that. But that's in y'all's decision as well. All right? It's been a pleasure to serve with y'all. Okay, thank you. Everybody rise, please. And y'all excused. God bless.
It's been a pleasure for your service, y'all. I love the accent.
Bless you. So you have a seat, please. So, counsel, what I'd like to do is take about a 5 or 10 minute break and then come back. We still need to schedule a sentencing hearing for these charges that were not the death penalty case. And then I also need to set a date for motions for new trial. I know we'll have to wait until the transcript is prepared. Do you have any, I know it's a long transcript, do you have any idea? You don't? Okay.
Maybe
Yeah.
set that date.
The jury is still sequestered. He just sent those 2 alternates home. So, as you just heard the judge say, they still have to schedule a sentencing hearing for the other charges that are not part of this death penalty trial, which means the CSAM charges. Am I right? I think so. I think that's what it means. So, yeah. I don't think there'll be another trial for that. Maybe he pleaded guilty to that. I don't know.
Yeah. Okay. We'll set the motion for a new trial day on the sentencing hearing. Obviously, y'all got to file within 30 days, but obviously you get time to review the transcripts as well. So if we got to reset that, we do. So if you'll give me about 10 minutes, we'll come back in here. I'll bring my calendar, and we can figure out when we can have the sentence. Anything else we need to do?
See, he talks like me. We want to bring my calendar in. That's what I do. That's what I do. I got to put that on the calendar. Love that. People are like, is that a planner? Is that a what? A calendar? A diary? Okay, they're going to make a note of that. So I think there's still a bit more before we go over to the Verdict Watch stream. Don't worry, you'll be teleported there. If you aren't going to stay for this for any reason, please check out my YouTube shorts. Because while we're on Verdict Watch, it's not live. The stream is waiting and ready to go. As soon as there's a verdict, you should get the notification, right? So how I update you if there's any jury questions is in the chat, and the mods also do a fantastic job at that, and so do all the chatters that are there, updating us on if there are any questions from the jury, what are they? But as soon as I know what the questions are, then I usually make a YouTube short for you, and you can hear them over there, and I update you on what's happening. Like when the judge says at 5 or 5:30 p.m., he'll check on the jurors, see how they're doing. Do they want to go home? Do they want to carry on? If they want to keep going, okay, great. Then I'll let you know as well. If they want to go home and come back tomorrow, I'll let you know that as well. I'll pin it in the chat, so check the pinned comments always in the live chat on those streams. We're waiting for the verdict, right? And then also check my YouTube shorts, because that's where I keep you posted.
Yes, Your Honor. Have you made a ruling as 13th juror?
On the what?
As the 13th juror.
I am not, but I will when I come back.
Thank
Is that okay? Okay. All right. See y'all in about 10 minutes.
Okay, and again, with our impeccable timing here today, this is great. We could just skip right forward until they come back, and we're only about 5 minutes behind the stream now.
October is kind of hectic. So with your...
This judge, is he my spirit animal? Is he like my twin? Is he like what? He's now talking about calendars, and he just said it's hectic. Okay. Speak the same language over here. Okay, so let's wait to see when they come back. Yeah, I don't want to miss anything. Forward. There.
So ideally, I'd like to do the sentencing hearing within 60 days, but my October is kind of hectic. So with your permission, what I'd like to do is I'd like to offer you either November 7th or November 12th. And if those dates don't work, I can give you some other dates.
I cannot do the 12th.
I can't do the 12th. I have a federal trial on 12th.
How's the 7th look?
7th is fine.
Just remember, if the judge, he's going to check on them at 5 or 5:30 p.m. Okay, so they're going out to deliberate now. And they will be, if they say, no, we want to come back tomorrow, they go back to the hotel. They are sequestered. All right?
Yeah, are you waiving my 60 days?
Yes.
Okay. Is that okay?
Yes, sir.
Okay, so I'm going to come back and visit y'all on November 7th if you've got a courtroom that I can use. And then we'll use this one in here. And that will be Finnegan sentencing. And so I think the way it's supposed to work is there'll be a pre-sentence report. And so whenever that's ready, if somebody could send that to me, that'd be great. And that'll be at 9 o'clock. And then I'm also going to sign this document saying that the juror questionnaires that we've printed today, I think is today the 21st or 22nd? 20th? It's Tuesday?
Yeah.
Is it really? Okay. I've lost time. So it's the 20th. I'm going to sign this order sealing the jury questionnaires. And I'm also going to sign this order pursuant to Criminal Procedure Rule 33D. The court accepts and approves the verdicts rendered by the jury, by the jury, and I'm going to sign that for today too.
Now, First Judge,
Yes, sir.
transcript order?
Yes, sir. And then the state gave me back their the capital case form. If y'all hadn't done that,
Oh, I've got it.
if you could just mail it to me.
We need to work on this more.
I think I've got it.
Let's work on it.
Yeah, I'm just a couple minutes left.
That's fine. Not much.
Oh, I've got this work. So.
And let's see. Let me go ahead and sign this verdict that I gave. I should make sure I get it when I sign it. I'll just make it She is. You told me to.
What? You said it. And then? There's no sound now. Okay. While you're all here, I just quickly want to run a poll. Okay, so stay here for a second. Stay here for a second. Okay, let's start a poll. What do you think? Well, sorry for my typing now. Okay. I just quickly asked you guys, what do you think the verdict will be? Life without parole? Will that be the verdict, or death sentence? In your opinion.
There you go, ma'am. And then here is the waiver. When you like that exhibit, that's the waiver he signed, giving up the right to testify.
That should be put in the charge.
Okay. There we go.
Okay, here's 3. It's already marked 2. Oh, it's 2. Yeah, this is already in.
Okay, you can keep it, or I guess give it to the clerk. It's not my copy. I thought that was the original.
No.
Well, this is my copy. Doesn't look like it.
Is the sticker on there? Or
Yeah,
is it?
sticker's on there. Looks like the original.
Okay, then I have the copy if that's the case, but let me look. Yeah, this has a real sticker on it.
Yeah. So that is the.
Maybe I got the copy. Is this yours?
Yes. I got it. So anything else for the state?
No.
Anything else for the?
Just real quick, Judge, I don't know the protocol on this. I'm not even sure if it's possible, but whenever probation comes to interview him, I'd like to be with him.
I'm not opposed to that at all.
They don't usually notify us of those things, so I'm not sure if there's a way for me to push a note to probation to have.
Why don't you notify them that I asked for a pre-sentence report and I asked that you be able to participate in that?
Okay, because they won't notice on
Yeah, well, if you'll do that letter and just say I asked for it, that's fine.
All right, thank you.
Anything else? Okay, keep your seats.
I wonder if there's anything more now. I don't know. Let me quickly refresh the feed. Please vote. Let me see how many of you voted. 564 votes. And there's like almost 4,000 people here. Put in your vote. Vote. What do you think the verdict will be? I know it could be what would you vote? But what do you think? After everything you heard, what do you think the verdict will be? Whew, it's a tricky one. Okay, now let me just quickly refresh this feed. Hold on 1 second. We'll turn the sound off and go like this just to make sure that we caught up. And I think they're on verdict watch now, right? Wow. Okay. Yep. There's nothing else. Oh my word. Did they decide on November 20th? Am I right? For that sentencing hearing on other charges. Interesting. Okay, okay. Gumshoe Lolly says, I don't normally encourage violence, but this guy is a savage. Whew. And the girlfriend of his as well. Like, ooh, dark, huh? Very dark. Oh my goodness. So, I'm just seeing what you guys are all saying. Okay, thank you so much for watching day 7 with me. Guess we're on verdict watch now. Are they going to vote for life without parole, or are they going to sentence him to death? Very interesting. Let's see. I just want to wait a little bit. 680 votes. Go, go, go. Click on it. Click on it if you haven't yet. Can you see the poll? Okay. Candace Carter said, if our chat is that torn, this might be a long deliberation. Right? I mean, it's almost 50-50. It's 54% so far say LWOP, life without parole, and 46% say death sentence. Wow. So can you imagine being the 12 that are deciding on this? Oh my goodness. Thank you, Scotty. I wasn't sure now. They chose between the 7th and the... Okay, so November 7th. November 7th. Scribbling that down. I'm sure you can hear me scribble. Yeah, someone says, Healing Art Dark is putting it mildly. Yeah, someone emailed to say they knew Rebecca in school, and they knew as a child, apparently, or when she was younger, she would, like, squeeze frogs until their eyes popped out. Like, oh, my word. Like, I don't know. Very hectic. As an example, besides everything else we heard. Yes, on day 1. Okay. All right. Are we ready to go to the Verdict Watch stream? You'll be redirected there now. And let's just take this one off. Wait. Yep. I don't think the judge is coming back to do anything there. I think they discussed all the things there. There's our little lighthouse. The judge said, be the lighthouse. Love that. I hope there will be full justice for, Jennifer Paxton. And I hope their family will be happy with the outcome as well. You know, I think they did very well today with their victim impact statements. So, yeah, I mean, imagine afterwards when the jury finds out about the other CSAM charges, previous kidnappings and all that. I'm always interested. So if any of the jury members, once everything is done, if they want to come and talk to us, they're always welcome to. My email is grizzlytruecrime@gmail.com. So, yes, Justice for Jennifer says, Bumbleb. Anonymous said, what's November 7th for? I think it's for the CSAM related charges. That happened in May of 2020. Jennifer Paxton was murdered in December of 2019. And in May of 2020, apparently Rebecca and Sean Finnegan together sexually abused 2 children, one under the age of 3. And they filmed it. They made CSAM content. I mean, what? So I think that's why. I mean, she's pleaded guilty for that already. She got life in prison, okay, for the murder of Jennifer Paxton and all those charges. And then plus 50 years for the CSAM. So I think the way that they were talking now, the judge was talking about the other charges, not part of this death penalty trial. And then they were looking for a sentencing hearing date for that. So I'll go back and check, but I think it was for that, for November 7th. Okay, have we got almost 1,000 votes? That's okay. It's still 50-50 just about. LWOP 54%, death sentence 46%. Very interesting. All right, so I'm going to redirect us now to the Verdict Watch stream. I will only go live when there's a verdict, whether that's later. I mean, obviously, if they go till midnight tonight, that's 6 a.m. for me. That means I'm going to be up all night. If the judge checks on them at 5 or 5:30 and says, okay, no, they want to go home being the hotel, their temporary home, okay, then they'll go back to the hotel, they'll have some dinner and all that, and they'll be back in the morning. I'll update you via YouTube Shorts, okay? Check out my YouTube Shorts. I'll also put it in the chat and pin it for you so you can see it there. And the mods and chatters always update us there as well. So keep me posted. If you see a verdict, email me, grizzlytruecrime@gmail.com. If you see a question, you can also email me. All right? So thank you so much. Megan says, I just want to say thank you for hosting the stream. Oh, thank you so much. I really appreciate that. It's always nice to be with you. I know the topics are very, very difficult. If you like the way that I present true crime or trials, we're kind of like a virtual jury, right? International mock jury. So because I'm not coming in here with like legal experience or things like that. I'm not a lawyer. That's what I mean, okay? So we're just looking at it maybe as jurors obviously would look at it. And so I find that very interesting. Of course, there might be a little bit of bias here and there. Why? Because we do homework before all these trials even start. We do trial prep, homework, look at rap sheets, previous charges and all that. So we come into it knowing a few things that the jury didn't get to see or hear. But either way, it's always great, watching with you and seeing what you all think. All opinions are welcome. I look forward to your comments as well. Also, if you missed the previous stream, which was Jennifer Soto's never before heard police interview, audio interview, go and listen to that. That was very interesting as well. All right, everyone, let's go to that Verdict Watch stream. I'll also put it in the chat in case you don't get teleported. Then just click on it and go there and click notify me. And I'll see you over there. All right, everyone. Bye.